Okay, it looks like we're live streaming and we're live and it's a couple minutes after 10. Welcome everyone to the commission to create a plan to incorporate the probate courts into the judicial branch. We're going to begin with some introductions of commission members, and then Representative Cardone is going to give some opening remarks. And so I'm just going to ask people to, let's start with going around the horseshoe this way. And then we'll take the inner horseshoe and then Representative Sheehan, and then I'll call on members who are participating by Zoom.
Jared Crockett, probate judge, Oxford County, representing the Maine Probate Judges Assembly.
Judge John Martin, I sit in Rockland.
I'm Leo Delicata. I'm an attorney with Legal Services for the Elderly.
I'm Kathleen Ayers. I'm registered probate from Kennebec County.
My name is Libby Mitchell. I'm the probate judge in Kennebec County, and I'm here for BLAC, which is the Family Law Advisory Commission.
And I'm Representative Erin Sheehan. I represent Biddeford's House District 12.
Thank you. I am Representative Barbara Cardone, the House Chair of this commission. I represent House District 127, which is part of Bangor. On behalf of myself and my co-chair,
I think we want to ask.
I forgot we've got others. I will hold on my remarks then.
We're also excited to begin. So let's see, Justice Gorman. Can those who are participating by Zoom hear us?
I can hear you. I can't hear Justice Gorman, but I don't think she said anything yet.
There have been some problems with Zoom today around the state. So if anybody's having trouble being heard, they need to get out and get back in probably.
Okay, thank you for that suggestion. Justice Gorman, do you mind logging out and then logging back in to see if that fixes the technology problem? Thank you.
I will email her.
Thank you. Okay, so to continue with our introductions, Judge Avantagio.
I'm William Avantagio. I'm the probate court judge in Lincoln County. I'm on this commission as the appointed member from the Probate and Trust Law Advisory Committee.
Thank you. And Julie Howard.
Sorry about that. I was emailing Justice Gorman. I'm Julie Howard. I'm the manager of operations and clerk of court in York County.
Thank you very much. And Tudor Goldsmith.
Good morning. I'm Tudor Goldsmith. I'm the state attorney at Jensen Baird, and I'm here on behalf of the Maine State Bar Association.
Thank you. And Justice Gorman, are you able to hear us now? Okay, hopefully that will do the trick. And then finally, we have Catherine Whitlock. Catherine, are you able to introduce yourself?
Okay, so I've just joined by my phone, and yes, this is Catherine Wiltuck, and I'm the Director of Court Process Planning and Services at the Maine Judicial Branch.
Thank you. Welcome, Justice Gorman. Are you able to hear us now?
I am. Thank you very much.
Good morning. I'm sorry that you've missed others' introductions of themselves, but we would all love to hear your introduction.
Good morning. My name is Ellen Gorman. I'm an Associate Justice on the Supreme Judicial Court, where I've served for 14 years. Before that, I was on the Superior Court for 7 years, and before that, on the District Court for 11 years. I'm currently the SJC liaison to all things family, and that includes FLAC and also the Family Rules Advisory Committee. I'm a former liaison to PATLAC and the Probate Rules Committee, and I was also the chair of the committee that implemented the changes necessitated by the Home Court Act. So I think that's why I'm here today.
Thank you very much. And I'll introduce myself. My name is Ann Carney, and I serve as co-chair of the Judiciary Committee. And I'm also co-chair of this commission with Representative Cardone, who's going to give us some opening remarks.
Thank you. On behalf of my co-chair and I'd like to welcome you all to this commission and thank you very much for volunteering to serve on this commission. And if you were conscripted as opposed to volunteering, thank you even more. We need and welcome the service of all of you. I hope that, before we get any further, I wanted to make sure that you all had met our two OPLA analysts, Janet Stocco and Sam Sneffet. If the two, if those guys have been great, they pulled together this program, they pulled together all the background materials, they will continue to support us in the 4 meetings that we have planned and in the writing of our report. If anywhere along the way, any of you have questions or need something or need to know how to do something, please feel free to contact Janet or Sam, and I believe you have their contact information. If you don't, they will be getting it to you very shortly. But please feel free to avail yourselves of their services. They are great, they are knowledgeable, and we're going to depend very heavily on them for the work that we're about to do. If you have had the opportunity to look at the background material that was posted on our website, you will know that it has been more than half a century at this point since Maine has been dealing with this question about reformation of the probate courts. In some ways, there are new issues, but in many ways, it's been the same issues over the last half century or more. I don't want to go into the details because we're going to be covering that later in the program. I just want to say it is my hope as co-chair of this commission that this is the last commission that needs to deal with these questions, because it is my goal, and I hope all of our goal, to be able to put together recommendations that can be converted to a piece of legislation that can be addressed in the coming legislative session to finally resolve these issues, or at least take a large step forward toward resolution and lay out a map as to what else needs to be done. So without further ado, I would like to turn the program over to Sam and Janet, who have put together some introductory materials for us that I think will be helpful as we work toward our goal. Thank you.
Okay, this is Janet Stocco from OPLA. I'm going to do a test of sharing screens, always dangerous. So hopefully you have seen, this is the website for the commission that you're all on, or if you're watching over YouTube, there is a website on the Maine Legislature's page that will give you information about the commission. Sam is going to go over the background materials shortly, but I did want to remind you of all why you're here today, which is the resolve passed by the legislature. If you ever misplace it and want to find it, it's linked right here at the top of the page. So as Representative Cardone said, there has been a more than half a century of study into whether to incorporate the probate courts into the judicial branch or what type of full-time probate court system to create since 1967, which is very slightly detailed in the emergency preamble to this resolve, but much more detailed in the material Sam is going to mention briefly soon. The resolve goes through it, talks about who the members are, but you know who you are, so we can skip that part. The appointments have been made, so we can get right down to the meat of the matter, which are the duties. And just to remind you, you are directed to create a plan for the probate court system that has full-time judges. The duties section of this resolve does tell you what types of factors to include in the plan, or to at least consider including in the plan, but it's up to whatever you determine to be relevant, including meaningful access to justice, judicial responsibility and adherence to the Code of Judicial Responsibility, qualified full-time judges, adequate professional staff, efficient practices in scheduling and case management, convenient and consumer-friendly processing of matters that are not contested, and then as well as economies of scale and all appropriate operational aspects. The one required part of the duties is that you shall describe how the system will be funded. In addition, it says that Sam and I are supposed to help you, so I guess we will answer your emails if you email us, since we are directed by legislation to do so. Okay, good. People are laughing. That means people are listening. And then I just wanted to reassure you that the report, although due on December 1st, Sam and I will put that together and then you will all have a chance to comment on it. The chairs have already requested an extension from the Legislative Council under the joint rules of the legislature. It can be extended once to December 15th. And that is because there are some tentative meeting dates that I think will be discussed at the end of today. One of them being November 30th. And they didn't want anybody to think that somehow magically there will be a final report the very next day. So that if you do have comments and you ask them to be included, you wouldn't think, well, nobody's going to listen because the report has to be presented tomorrow. We will in fact listen, and hopefully the council will give us that extension to make sure that your comments are fully incorporated. So that is the background from here. And then I believe Sam would like to talk to you about your blue binders and then some background material.
Great. So please let me know if I'm not talking loud enough. It's a chronic problem for me. I just wanted to go over a couple things to make sure everyone is oriented. Everybody should have a binder. It is blue. If you are attending remotely, you should have received your binder in advance. And the folks here have it in front of them. You'll find a number of things in that binder. There's a table of contents in the front of it. The authorizing legislation, which Janet just reviewed, is included. A list of all commission members is also included, as well as a fair amount of background material. If you have neither the time nor inclination to read through all of those pages, and there's a lot of them, we did prepare a brief summary. It is in this kind of alarming lime green color, and that is available for you to just get a kind of snapshot of each of those documents. We thought that might be helpful for folks. And later today, we will be hearing from Deirdre Smith of the University of Maine. And I would recommend, if you do have limited time to read these materials, you might start with her article From Orphans to Families in Crisis, Parental Rights Matters in Maine Probate Courts. She provides a very nice overview of the history of this issue. So that is a good accessible article, a good place to start. Also, as Janet said, all of these materials are posted on our website and are linked in this summary, there are hyperlinks that link to all the materials as well, but then they're separately listed on the website. So hopefully those are all easy to access. Some of them we had to kind of dig up from the law library to get posted, but they should all be available to you. And I think those are the things that we wanted you to know just at the outset. And again, as Janet had said, and the chairs had noted, we are available at any time. Any questions you have, either if it's, I'm having trouble with Zoom, how can I make it work better? Or I'm looking for this document, could you help me find it? We are so happy to do that. That's what we're here for. So thank you very much.
And I did forget to mention about Freedom of Access Act. So all the legislators are aware of this in their regular duties, but as a member of a legislative study, this is a public proceeding, which is why it's being broadcast over YouTube. The audio is being streamed live. We have invited the public. They are available. If you're watching over YouTube, you are actually able to come into the State House now. It's not closed. You could come and watch the meeting here in person if you so choose. But we would, for that reason, ask, I don't know, I had to step out to the restroom, so this may have already been said, but if not, if you have a comment to make, please don't make it through the chat on Zoom, because that is not being broadcast to the public and that would not provide very good public access. You are, however, able to talk about technical issues like your audio is not working, you forgot to mute, or I have to log out for a second, I'll be right back. That is absolutely acceptable and fine. We just want to make sure that the public does have access to all of the substantive comments.
I did want to follow up on Janet's comments about using the chat. We have some meeting reminders about today's meeting, and we are hoping that each meeting of the commission will be able to be conducted in at least this hybrid format, if not in person. But things are a little different with the hybrid format. So there are a couple of announcements that I wanted to make, some of which relate to the people who are here in the room and some of which relate to all of us. Bathrooms in the State House are located just down the hallway. We will have a lunch break from 1 to 1:30. There was a mechanism for ordering from Panera for those who are in the State House. And then the Cross Cafe is located in the basement of the Cross building across the way. And they have some limited grab and go options. As far as the hybrid meeting format, some of us are here in person and some of us are participating remotely. And in addition, our proceedings are being live streamed on YouTube. There's also a live audio stream that's available. Members who are attending in person should make sure their cell phones and computers are silenced. If you're logged into the Zoom meeting, make sure that you remain muted at all times. When anyone attending in person wants to speak, please turn on your microphone in front of you and also just raise your hand and wave it to make sure that I see your hand. And I'll either Barbara, Representative Cardone, or I will call on you. And then turn on your microphone to speak, and please remember to turn it off when you're finished. Members who are attended remotely should also mute their Zoom audio when not speaking. But if you would like to ask a question, please physically raise your hand and wave it on the screen, because we'll both be watching the screen and the room. And then also, if you're comfortable using the raise hand function, please do that as well, because that promotes you to a specific part of the video screen and makes it really easy for us to see. Public health precautions. Everyone who is participating, who's attending in person, has to comply with the legislature's COVID-19 prevention policy. And that includes wearing protective face coverings and self-screening prior to arriving at the State House. Technical issues, if you have technical issues, as Janet said, please use the chat function to reach out to us, but the chat function isn't part of the official public record. So please don't put anything substantive in there. If you would like to communicate with us substantively, please email Janet or Sam or Representative Cardone or myself, and your comments will become part of the public comments record and an official part of the deliberations of the commission. The meeting materials have been so thoroughly prepared and reviewed by Janet and Sam. And then just one other thing, when lunch begins, we'll give you a little reminder to turn off your audio and video during the lunch break if you're on Zoom, but to please stay logged in. I think I covered all of that. Before we move on, are there any questions? First, I'll ask those who are participating by Zoom. Do you have any questions about the process or any of the reminders that I just mentioned? Looks like everybody is just fine. Great. And then for those who are present in around the horseshoe, so to speak, are there any questions? Great. Thank you very much. All right. So I think that we're done with a lot of our preliminary matters. And at this point, we're ahead of schedule, which is really wonderful. Sam and Janet, did you have other overviews of the duties and background material? Okay, wonderful. So then we can begin the next item on our agenda. And that item is 2 presentations. One is introduction to what we call the front end of the probate courts. And that's going to be done by Kathy Ayers, the Kennebec County Register of Probate, who's here sitting in the center of the horseshoe. And then we'll also do an introduction to the quote back end of the probate courts. And that will be done by Judge Mitchell and Judge Avantagio. And then we'll follow that with a question and answer period. And so at this point, I would like to introduce Kathy Ayers. And Kathy, will you please let us know how you'd like to handle any questions that come up during your presentation? Would you like people to wait till the question and answer period or raise their hands during?
It matters not to me. So
Okay.
whatever you prefer.
Okay, so I would say if people have a kind of a clarifying question, raise your hand and ask it now. But if it's a more of a discussion related question, we could save that till after both presentations so that we can have a real robust conversation. Thank you, Kathy.
Yeah, I'm Kathleen Ayers and I'm the Register of Probate from Kennebec County. Can you hear me okay through this thick mask? I've been in the probate courts for 28 years and my mother was Register of Probate 19 years before me. So I have a lot of history behind me on the probate courts. Most of this you already know, but I'm just gonna go over. I did mostly the non-probate functions of the registrar. So we're elected by the people of our counties, and in 16 counties, we have people new as 9 months and registrars that have been there for in the probate system for over 40 years. The judge is our supervisor for the court and for the registrar and the staff. We also have people who have authority over us in other places, and that is county commissioners. And each county has a municipal budget committee made up of town officials, and they have the final say on our budgets countywide. The Supreme Court, of course, through rules, and the main state legislatures through statutes. We have a lot of bosses. We have a lot of bosses. So, and in a large court, I just want to say in a larger court, like mine, where I have staff, a lot of our responsibilities are delved out to other people. In smaller counties where there are only a few, as few as 2, and one county with a part-time registrar, it's a totally different story. And we are chief cook and bottle washer. And some of our responsibilities are the quasi-judicial role in informal estates, which does take up, informal estates are more than half of the current dockets, the first initial dockets. So they're more than half of our work. We have a court clerk role. Some of us sit in and do the taping of the trials. We're the ones who have to do, find guardian ad litems and attorneys for appointments. We do a lot of jobs in the court clerk role. We also have administrative roles on budgets because we prepare the budgets. We have to take the budgets through 2 committees and an administrator at most times, an administrator, the county commissioners, and then the municipal budget hearings. We also have a supervisory role as on personnel. Some of us do have HR departments, but we still do have to do the everyday supervising of our workers. We have a fiduciary role in accounting for fees and outgoing expenses. We have a law clerk role in research and updates on rules, forms, and appeals. We also are very proud of our preservation of historical records. And we have records that are the history of Maine from the very beginning of York County. So we have a fund to preserve these records, and we're trying to make sure that the original exemplified copies of wills from England that are land grants and important documents like this are kept and preserved. And we're also trying to put them on the internet on our system, our mainprobate.net, so that people can look at them and get them without coming and to the office. And in COVID times, that has been especially poignant. It's a big job, but it's a very important job because it is our history. And cases generally, I just want to go over the types of cases. We have non-probate cases, meaning we have everyone who dies in any county usually calls the probate court, and we have to direct people, and I'll get into that a little bit later. An informal probate, which is probates that are perfect and don't need a judge's attention. Formal probates, the judge's role, estates, of course, but I'll get into what the other cases that they hear are. Other duties of a non-judicial nature, there's a few things that nobody has a clue that we do, and we'll touch on that too. I'm going to start with the non-probate cases. What do you do when someone dies? You call probate or you go to probate. That's usually how it works, unless you're very sophisticated and have been through it before. Issued in a case where there is not enough assets to probate is what we call a letter of no probate. This is standard proof nationwide of no estate in the county of death. So it's a pretty standard everyday used thing across the country. And if you split formals and informals, there would need to be some repository of that information. So other assistance that you give in non-probate are forms like the affidavit of collection of personal property. We also have to direct people to vital statistics for death certificates, town office for forms, motor vehicle for title issues when there's only a car. And that's the biggest reason we have non-probate issues is vehicles and intangible properties and small bank accounts. We also direct people to legal services, either your own attorney or legal services for the elderly, Pine Tree, and others. We also have to direct people to the police because we have issues when people have suicide or drug overdoses and they only have a laptop or a phone or something that they need to collect. And also, we have to direct people to, of course, other probate forms, either the informal forms, or if you are, I'm gonna go back to the suicide. We also have other forms like special administrator that go to the formal realm, to collect, to find a will, to go to the bank, to get in a deposit box. And we'll also direct people to the main probate.net where all our forms are. Should they need a formal proceeding, all the forms are there for them to look at. An informal probate proceedings, these are the proceedings. We have an application to have a will allowed, meaning if you don't need to have an executor, but you want the will to be made good forever, that is the way that you would do that. An intestate and an appointment of personal representative, forever known as PR, that's with no will, an intestate. Testate with an appointment of personal representative is with a will. We also have summary administration, which is a little different of a process, where you need one thing taken care of. It's a simple thing, and it's not over the $40,000. And we would grant you PR and close it almost immediately after you've taken care of the item. Usually, the only few times this has been done in my court is a spouse who is having problems with a finance company and they won't deal with them. Or so it's very, very limited. Domiciliary personal representative is a big one. It is real estate, and the probate isn't in another state. So we're recognizing the authority of the other state. And an informal special administrator, these are not done very often because they're required to be bonded in the informal world, but it has been done on, again, this in other counties, it's been done with the safety deposit box, putting your will in a safety deposit box and nobody else has access to it. That is one of something that happens pretty frequently. Informal applications. So the register can decline to probate an estate informally. A formal petition would need to be filed. Reasons are most often the person with priority refuses to act, is unwilling or unable to be the personal representative. Only a copy of the will can be found. That's a reason if you only have a copy. Problems with a holographic will, and the will is deficient in some other way. Informal appointment. So the register accepts the filing and the application must be correct and no bond be required. By mail, there's a lot of going back and forth with people on these. Filed over the counter in-house, we give them the paperwork back for corrections and they sit right there and do it, or they sit right there and fill it out, which is also mostly the case. If it's e-filed, it's rejected with an explanation and corrections for resubmission. Most common reasons why applications are sent back for corrections: no renunciation from the person with priority, missing names or addresses of heirs and devisees, and location of the real estate, which is really a little teeny thing, but it gets forgotten a lot. Appointment is made and letters of authority are issued if the application is correct. Testate only after the original will comes in and is valid. All necessary renunciations have been filed, findings are made, and letters are issued. The time it takes to process depends on staff availability. This comes to a uniformity issue, again, where if you have a small staff or an overworked staff, it's going to take longer to get your letters of authority, but it's usually done very quickly. In my office, it's done in a couple of days at the most. And so it is dependent on from county to county. After appointment, notice is given to all interested parties, including DHHS, third-party liability for decedents over 55. Publications for creditors notice is prepared and published. Special publications for unknown heirs as well. Real estate abstracts are prepared and recorded at the Registry of Deeds. Demands for notice are filed and copies sent per request. Claims against the estate are filed and copied to PR if required. Correspondence for copies requests and claimants for claimants and devisees. We issue certificates of appointment and in the end, a sworn statement closing. Current certificates of appointment and exemplified copies of wills and records. Current certificates of appointments are issued on request. They are used by banks, stocks and bonds companies, insurance companies, real estate transactions, IRS, and many other important businesses. Exemplified copies of wills and probates as well as in any other types of cases. Important for domiciliary proceedings and court cases involving real estate disputes. Some will exemplifications are used even now in cases that date back centuries. Most common problems with wills: can't find the original, cross out, no initials, one witness, no rest residue clause, no PR appointment, no alternative PR appointment. Nobody knows who's going to die first. This just in. Written in someone else's hand and signed by the testator. The next thing that we do is the domiciliary foreign representative. And it is, especially in the lake regions, we are recognizing the authority from the other state, and we get their exemplified copies of the will. And then I just briefly touched on what the judge does, even though it's a very big thing. Formal proceedings categories, just the categories. The estates, of course, they get the estates in controversy. And then guardianships and conservatorships of adults and minors, which that's only 4 words, but that's a really, 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 really big job. I can't even, they're going to tell you. They're going to tell you how big a job that is. Adoptions and terminations. Civil complaints and name changes and for adults and minors. Those are all the judge's realm, I like to call them. Other duties of a non-judicial nature, we have to check guardianship files for the police departments in a request for concealed weapon applications. Some counties do passports. Passport applications are not in all counties, but they are in some of the smaller counties where there's not the opportunity right around the corner like it is here. And confirming identity of applications for personal representatives in other states. Other states have a process where you go to the county probate court where you live, they send us the documents, and we have to confirm the person's identity when they sign the documents and send it back to the other state. So that's just one of those things that it's not every day, but it is one of those things that we do that nobody really knows about. So that, I think I've talked, what did I do? I did pretty good, 20 minutes.
I think, thank you so much, Kathleen. That was very informative. And I just want to take a little break here, and I know we'll have some discussion related questions and answers at the end of Judge Mitchell's presentation. But do members of the commission have questions for Kathleen Ayers that relate to kind of follow-up questions or points of clarification? Representative Cardone?
Kathy, thank you. I appreciate the magnitude of the work that registers of probate do. What would you say is the biggest challenge or need that the registers of probate are facing today?
I think the biggest challenge that we're facing today is in the guardianship realm. I mean, just the overlap of law between the involuntary commitments and the extra hearings that we have in the new code and the lack of attorneys that we have to handle these kind of cases and finding attorneys to handle these cases. I think that has to be that has to be the biggest challenge right now. It really does. It's
if I could follow up, I just want to make sure I understand this, because I think you've articulated 2 or 3 different areas that fall under guardianship. One you said is the overlap. You're talking about the jurisdictional overlap with the district court?
That's correct. Yeah.
Okay. And why is that a problem or a challenge? Is it a communication issue?
Yeah, you can't, the judges can't have the same information. We have a judge that's trying to do guardianship and we have someone committed. And we've had people let go from Riverview when they were under guardianship that have never been heard from again. So, yeah, I do think this is there needs to be it's almost like the home court rule for adults because they have to be able to talk to each other, these judges that are hearing the same person, the same case. And we have a really hard time finding attorneys for these emergency guardianships.
Okay, and that was a second issue, the lack of attorneys.
Yeah.
They're just not, and we've heard this in other cases about other things, but they're just not attorneys available to do this work at this point.
Right,
correct?
in this area of law, yeah.
The third thing you mentioned was, I think you said the words extra work. Were you talking about the need for more attorneys, or were you talking about the need for more staff in the probate registrar's offices?
There's a lot of courts that needs more staff. There are. I have a guardianship clerk. I have a clerk that just does guardianships, but someone who has 2 people, I don't, there's so much, how do I say, intricate, important work that needs to be done that you need a clerk for the specialized in these areas.
Okay, thank you.
I have a follow-up to Representative Cardone's and then Justice Gorman, I'll call on you, but is there a recommended level of staffing within the registrar's office based on population of the county? Or is there a standard in Maine, even if there's not a recommendation?
There's no standard and there's no recommendation. No. Like I said, in Androscoggin County, they only have a part-time registrar. That to me is insane. With the amount of people that live in Androscoggin County. So I don't know what you can, what could be done about that, but it seems like it would slow things down and not get the job done, so.
Thank you for sharing that information. Justice Gorman?
Good morning, Kathy. How are you?
Fine, thank you.
So you've demonstrated just a wealth of information here, and you've explained the very broad reach of your experience. And my question is, you've been doing this now for a few years. Was there on-the-job training, and is there on-the-job training? Because the statute doesn't require any sort of pre-existing knowledge or experience or anything else. And these are elected positions. So if you were newly elected, how would you get trained and by whom?
Well, that is a very good question. Because I was lucky enough, like I said, to have a mother who was a register of probate. And she basically groomed me for this job. So, but the Registers Association has tried to do, first we did a policy book of how to do A, B, C for new registrars. Unfortunately, the association has had issues with participation because of the busyness of the courts. So it is difficult for new registrars, but they should have a deputy in place that knows the procedures and knows the system, but it is ever changing. So we do trainings. COVID has really put a damper on our trainings in the last couple of years. So I do feel for the newly elected registrars, but we do talk to each other and work with each other quite a bit. And that is how we train. We lean on each other. So.
Thank you.
Are there additional questions among those who are participating remotely? And not seeing any. How about for those? Go ahead.
Thank you, Madam Chair. Registrars, you've been through this process a couple of times between your mother's experience and your own, the Futures Commission and so forth. There's certain information in order to develop this roadmap to some sort of consolidation or reform that we're going to need, I think, based on past reports. And I wanted, one, get your view of it, but two, I wanted to ask, I mean, in terms of open cases and dockets, I mean, we have new dockets each year, but how many open dockets does even a court like Kennebec have with the adult guardianships that can go on 40, 50 years? I mean, is there a ballpark? Because we have to try to put together a number.
Right, that's a tough one. With the new dockets, I can tell you there's less than 800. There's 750 to 800, including the adoptions. But the ongoing guardianships, figuring out how many are out there is a little bit difficult, but we've all started to ask for the new required reports and plans and status reports. And so we're going back and finding, because we used to have the former Judge Mitchell would say, we have when you were granted guardianship, you're on your own, basically, you were on your own, but now you're reporting back to the court. And we didn't have a mandate to go back, but we are going back and getting people to do those reports. So I think the only way we're going to figure out how many people we're dealing with yearly is the new dockets and the new filings of reports.
So in terms of putting out a questionnaire to the registers to try to, because you're just one county, I mean, we've still got to do the other 15.
Yeah.
Is there any format that we've used for a questionnaire in the past to try to get some of this information so we can come up with court hours and so forth to come up with a plan? Is there anything that has been used in the past so we don't have to reinvent the wheel?
I don't think there's been anything as comprehensive as we need.
Okay.
I really don't. It's been a long time since getting the time to just do these things for some counties is, nearly impossible. I mean, some of them, we don't hear from. So I don't know how you can fix that. But we should be able to get statistics from our system.
Yeah.
We should.
So Madam Chair, if I may, one last question. First of all, I know that you are the guru among registers. All registers call you with questions and you're a great resource for all of them. And I appreciate it for my own county. So I'm figuring you might have a ballpark idea. When I ask, what percentage of the cases that come before you are all pro se, no attorneys? Because I know they're the most complex cases because you're dealing with estates that can be upwards of $1 million with no attorneys involved. Or adult guardianships where the continuing jurisdiction, there's no attorney because the attorney withdraws after a certain point. What percentage of pro ses are you at?
I'd be wild guessing, but I'm sure it's over 50%.
Thank you.
Thank you. Other questions from those around the horseshoe? Any other questions from folks on Zoom? Yes, go ahead.
Hi,
Julie.
I'd like to follow up on something that was just said, and I just want to be clear on it. So are there any statistics that are shared among the probate courts as far as caseload, just basic caseload statistics?
I think 2018 was the last time that I got them together from I'm also the president of the association. And it was difficult. It was difficult to get them, but it can be done. It can be done.
Can I follow up on that? Are all the probate courts on the same computer system?
We are on the same vendor. We are not combined together. We have the same program. We have the same system. We have a great vendor who works with us. And, so I've heard things like they can't interface with the state system, but our system, you can PDF the whole case and email it. I mean, we have a pretty good system. It has a lot of bells and whistles that a lot of counties are not using because again, they don't have time to learn. And it's some of the smaller counties, and I'm not picking on all of them because Lincoln County's sitting in your group and they're wonderful and so, they get it done. But it does have a lot of good things that you can use to get these things. But, like some counties weren't even putting on adoptions on the computer system. They kept the old docket going and things like that. So it's not an easy task, but it's going to have to be done.
And who's the vendor?
Icon.
Can you spell that?
AICON. And they're
Okay.
from Georgia. Yeah.
Great, thank you.
Other questions from those participating on Zoom? Not seeing, I actually had, Kathy, a couple of follow-up questions to those. To what extent is electronic filing used within the different county probate courts? Isn't it kind of uniformly used?
It's uniformly used. Yes. Yeah. All right. We have the court rules make it so. So yeah, attorneys all have to use the electronic filing system.
And how about pro se?
Pro ses can use it, but it's very limited. It's very limited. Pro ses are still coming in over the counter. They're still doing by mail. And then the attorneys are the ones using the electronic system.
And so if pro ses are about half of the people who come to probate court for help, so is it approximately half of the cases are using the electronic system?
Yeah, and I can give you certainly a better number on that for real.
Okay, thank you.
When I get back.
I have a feeling we're going to be asking you for a lot of information, and I just want to express a lot of gratitude in advance. I know that you are the guru, and we appreciate your participation. Go ahead, Judge Crockett.
Thank you, Madam Chair. So as a follow-up to Madam Chair's excellent question, you have courts that go back, well, 200 years in some cases that predate the state of Maine, and my own does. How far back have you gotten in your records to update some of this stuff, to scan in? I mean, I know that every court is kind of at a different point, but I'm wondering if you have a pulse of where where all the courts are.
I really don't. And we have a lot of ours on, and we have a system so that if you need one, that we'll put it on for you. But I don't, that's something I have not pulled or anything in the association.
Other questions? I am not seeing any in person or electronically. Thank you so much, Kathy, for that wealth of information. And at this point, I think we'll turn to Judge Mitchell, if you are ready to talk about the back end, so to speak.
Do Judge Avantagio first.
Oh, excuse me. I saw the note and then I promptly forgot about it. Thank you. So at this point, we will welcome Judge Avantagio to speak about the back end of the probate court system, and he's going to focus on wills, trusts, and estates. Thank you very much.
Good morning, folks. Thank you for your time. I wasn't sure who was going first either, so I've just been waiting patiently. So a large part of what the probate court does, and probably what most of the public thinks that the probate court does, is deal with people's stuff after they die. And Kathy gave you a simple overview of that, and I'm not going to try to get too deep into it because it is pages and pages of stuff and more than you need. But broad strokes, somebody dies, they either have no will, or they have a very good will, or they have a bad will. The good wills are easy. We have statutes that provide for what's called a self-proving will. It's witnessed and notarized, and it comes in, and I and the other judges, unless somebody comes in and contests that, usually don't see it. The registers process it. It goes through what's called an informal process, and it all goes through on, I guess, what we're calling the front end of the house, without judicial oversight unless it is requested. And people can come in and contest the signing or contest other parts of it. There are elections that can be taken if the wills don't provide enough for a surviving spouse, for example, but usually we don't see those. Bad wills can create a whole lot more process and entertainment. Wills can be written with the best of intention, but not particularly well. There was a case back in the 30s, I think, in Canada, where a farmer trapped under a tractor scrawled with his penknife on the side of the tractor, "In case I die in this mess, I leave all to the wife." And that piece of tractor was brought into court, and that was a valid holographic will. You heard Ms. Ayers refer to a holographic will is written in the testator's hand by the testator, preferably dated and signed. But largely what we're trying to do is determine whether this is actually something that was written by the testator, and whether it is a valid will and what that person's intent was in that. One of the probate judges at a conference a few years ago told a story about a handwritten will that said, "When I die, I leave all to my darling Eileen." And that was crossed out, and above that was a series of 4 different women's names for the series of women who had come through this gentleman's life, all done properly. And so no difficulty, but a little bit more oversight, a lot more oversight than what would come through on a perfect self-proving will. And then there are folks with no wills at all who are what we call intestate. And there are a number of rules on how things go then. And those and the bad wills are always what we call the formal process. And the formal process comes before the judges. Notice is sent out to everybody who's got an interest in that. Sometimes it's known creditors, people who may have been, it can be known people involved in this person's life, but certainly surviving spouses, adult children, parents, the obvious candidates. And there are rules for how things process out when somebody dies without a will. And some of it is logical and some of it is just that old saw about what comes out of committees and legislatures. Oftentimes what we're dealing with is just the next step in the judicial process for dysfunctional families. People come in with complaints that really don't have anything to do with wills. They have to do with injustices that are still felt from their childhood, not being the preferred child, not being the preferred spouse. This new spouse came in and took over our father, our mother, whatever. So there are the personal things to sort through as best we can and sort of have people feel heard, but also apply the law as it's written in 18C, as it's been interpreted some. And some of this stuff is really ancient law. And that's a fair amount of what we do. We also have jurisdiction over trusts. People, for a variety of reasons, some people, I should say, wish to keep control over their assets after their death and sometimes long after their death. And those can be as simple as I give this property, this money to this person to hold until my child turns 18. Not a whole lot more direction than use it as you think is best for their care and education, and then turn it over to them at that point. But they can be very convoluted, very detailed. If there are disputes about how a trust is being administered, the people who are supposed to be recipients of those trusts can come into court and ask for a review of that, accountings, interpretations. We have jurisdiction to terminate trusts if circumstances allow, and often if people agree. We have jurisdiction to interpret, as I said, or modify a trust. I had a case last year of a trust that was set up in the 1800s in Waldoboro, a town in Lincoln County, for the benefit of widows and orphans of, I think it was Finnish descent, and it had been still administered, but the state of the reality in Maine has been for a long time that we don't have orphans anymore. The state steps in long before that, and trying to find widows of Finnish descent in Waldoboro was getting more and more difficult. And so the trustees had come in and said, we think what this person wanted to do was to benefit a group, class of people. So here's what we would like to do with this. There were banks that were down the line beneficiaries who were all on board, and they presented what seemed like a reasonable plan. No Finnish widows showed up to object that they weren't getting what they were supposed to get. So I modified the trust to make new provisions, really, for what a trust that made perfect sense when it was granted and for some period afterward, but had just been stuck stagnant because the trustees couldn't find beneficiaries for what the original trust had intended to be. And there are things in that trust provisions that candidly, I don't know they're there until somebody files something and says, here's what we're asking you to do. And I pull the books down and try to figure out how that happens and what happens next. The largest part of what I find myself doing, I think Ms. Ayers referred to recently, is, however, adult and minor guardianships. And Judge Mitchell, I think, is going to give you some information on those. I'm happy to answer some questions, but I think what my task was here was to give you a broad overview of what the scope is of what we deal with in probate court.
Thank you very much, Judge Avantagio. Among the members who are participating via Zoom, are there questions? Not seeing any. And how about for those who are around the horseshoe? Questions? Go ahead, Representative Cardone.
Thank you. Judge Avantagio, with respect to the estates and trust dockets around the state, Are these dockets generally given adequate resources by the counties so that you can cover these dockets in a expedient time, address these needs as they need to be addressed?
I'm really not in a position to speak about around the state. We are individual courts. I don't think it's a luxury, but it is at least a benefit to work in a county where my registrar largely, she runs it past me, but she does the lion's share of the work, puts together a budget, puts it before the county commissioners, and it's approved without question. So my court is scheduled on Wednesdays. I'm there sometimes half day, sometimes full day. If there are cases that need to be heard, I will schedule other days to make sure that they're heard. But I haven't had any trouble with not having enough time or being able to give enough time to get things processed expediently in my mind. Trust and will stuff really aren't the things that take more immediate processes. Usually it's the emergency guardianships of adults and children that require more immediate attention. We will get people who are in the hospital, don't have advanced care directives set up, and need somebody's coming in to say, I need permission now to get this done, to stop transfers from this trust. Somebody's trying to take advantage of my mother, my sister, my brother, whatever. The delays in trust and will administration are usually procedural delays with attorneys trying to seek information, not improper delays, but sometimes it just takes time to track things down, particularly when you're dealing with estates and we don't necessarily know where things are. Some people are much better about putting their important documents in predictable places. And sometimes people have to toss the house, find a key, figure out what key that bank deposit box goes to, get permission to get into that box. So sometimes it's just a matter of giving time for the participants, the litigants, to gather the information that they need. I haven't had any difficulty, I don't think, in having enough time to process wills and trusts efficiently. Nobody's made it known to me, at least, that things aren't moving quickly enough.
Thank you.
Yes, go ahead.
Thank you, Judge Avantaggio, for both appearing today and for protecting the Finnish widows. I got one question. I guess I know you're just one of the 16 courts, but what percentage, and this is a relevant piece of information because we've got to find out how many of these estates already end up within the judicial branch as part of a potential transition. So obviously the probate courts exercise concurrent jurisdiction with Superior Court on wills and the states and trusts. What percentage of your cases are transferred to the Superior Court? Do you have a ballpark?
Oh, very few. We only get a transfer if somebody files something that brings in that jurisdiction. So I think right now I have on my entire docket one case that is being held because adult sons in a case that started with a contested guardianship. Their mom died during the guardianship. She had amended her will to leave significant parts of her estate to the folks who were caring for her. And so they have filed contests of that, interference with expectancies, complaints, and requested transfer of that to Superior Court. I met with Justice Billings and we came up with a plan of how that was going to be handled. So he's handling all of the discovery aspects of that and will resolve his side of that. And then whatever's left will come back to me on the will itself, if the will survives the action that's pending before his court. So that's the only case that I can think of in my 6 years of doing it that's been transferred to Superior Court. There was one other that was filed. So 2 in 6 years in my court.
Other questions from those around the horseshoe? Go ahead, Leo.
Yes, Judge Avantaggio, how many of your cases over the last 6 years have been contested cases that have required a hearing, either on a motion or a trial?
That's a difficult question. Remember, a lot of cases that are filed, I never see. It's handled in the front office, and they're on the docket and processed through, but the folders never come in front of me. Most contested hearings are guardianship cases, and sometimes those are sort of formally contested, but not actually contested. We have hearings. If somebody comes to the court asking for control over your body, your assets, first thing is to send a visitor out, somebody appointed by the court who comes and gives you papers and tries to explain that process to you and give me an idea of what your level of disability or not, comprehension or not, whether you would like an attorney, whether you contest this or not. But even if you say, that's my daughter, I don't have a problem with that, I have a hearing and hear from you and hear from the physician often, or the number of people in the medical field that can fill out a document that says what your ailment is, why you need help. So those are contested light, but I couldn't put a percentage on it. I have some sort of contested hearing probably every other week, and I'm in court once a week generally. Sometimes I've got contested hearings that are 3 days out of a week. But as far as numbers, I couldn't do percentages or just gross numbers. It is regular. I don't have a automatic referral to mediation system. If it seems like something that can help, I'll refer folks to mediation. If it seems like something that needs to have a hearing, we'll do a pretrial conference, see what needs to happen, and get it scheduled for a hearing. I've got, I think for litigants, an ability that they may not understand to move cases through the system in a few months rather than 18.
So in the last year, can you tell me how many, or approximately how many times you've had a hearing where there's been attorneys on both sides of the issues?
Oh, fewer than 10. Attorneys, for obvious reasons, are usually better at sorting out the problems and understanding where cases are likely to go. When we're dealing with a disgruntled adult child who just doesn't think because dad always said I could have that, I don't care what his will said, there must have been some interference. There isn't anything that's really going to resolve it except a hearing and having them put on the evidence that they have.
Thank you.
You're welcome.
Other questions? Yes, go ahead.
This is just one follow-up, and I think it's probably for the benefit of the whole group. And I got to ask this question of you: is in my court, I have cases that my oldest docket number is 1918, 1919. That's my oldest still open docket for trusts. What's your oldest, just curiously? And do you have any idea how many you have that are still open?
I don't have anything in active litigation that's that old. Those sorts of things are technically open as long as the trust is open. The oldest stuff that I see regularly are, we get annual reports from guardians and conservators. And so I've got reports from usually parents whose adult children are under guardianship. And these folks could be in their 50s and their parents in their 70s or older, who are still taking care of their adult children who aren't able to take care of themselves. So I would say those are, I reviewed one last week that was from the mid 60s.
All set. And Julie Howard, did you want to go ahead with your question? Thank you.
Sorry. Sorry, I'm having computer issues here. and this might not be appropriate to ask you, Judge, but in each county, is there just one probate courtroom or are there multiple probate courtrooms? I'm just trying to understand the need for space.
I believe there's only one courtroom in any county. Saginaw County right now doesn't have a probate courtroom. The Sheriff's Department took it over, so they use whatever space that they can find on a given day.
Okay, I'm going to hold my next question. Thank you.
You're welcome.
Thank you. I actually had a follow-up to Representative Cardone's question. She asked you about financial resources. And how about the issues with regard to training for registers and staff? Do you feel that the training opportunities, both kind of the availability of a training opportunity and also the opportunity for people to actually attend the available trainings, do you feel like that is sufficient or insufficient at this time?
Probably a better question for Ms. Ayers. I am very fortunate to have a registrar who, as Ms. Ayers says, gets things done. I know when the Title 18C was coming in, the registrars group, and I don't recall what they're called right now, was very active in scheduling and getting together to make sure that they were on the same page with forms and processes. And that was interrupted by COVID, but the transition in my court felt almost seamless. We certainly had some glitches here and there because it was just a completely new set of laws, set of forms that we needed to get up and running. But I think they do a very good job among themselves of supporting themselves, being available for questions. If there are questions that I ask my registrar and she says, I'm not sure, she'll call Kathy, or the Knox probate register is also a great resource. They do very well supporting each other without any sort of formal statewide training system.
Thank you. Tudor Goldsmith, do you have a question?
Yes. Hi, good morning, Your Honor. Somebody asked a few moments ago about concurrent jurisdiction and removal to Superior or District Court. And I was wondering if you could just please clarify the matters for which the probate court has original jurisdiction, and you kind of touched upon how a case comes back to you afterwards. If you could just kind of explain that maybe in a little more detail. Thank you.
Oh, I don't think I could confidently give you a full overview of that. There are matters that are strictly probate, and there are matters that can bring in other issues of law, such as interference with an expectancy that may have a right to trial by jury. If you've got a right to trial by jury, you've got a right to move that to Superior Court. That's the biggest one that comes up. If it is strictly a probate question, then it stays in probate. But on the case that you're referring to, the judge in Superior Court won't decide who gets what in the final analysis, but he can decide, or a jury can decide, however they handle that, whether the will that has been presented to my court is a valid will, or whether it's been brought about by some sort of subterfuge or fraud. So with that question decided, the will itself will or will not come back to me to be administered at the estate level. I don't think that's a very complete question. I'm sorry, complete answer rather, but.
Did you have a follow-up? Are you all set?
Thank you.
Great, thank you both. Other questions, either from those remote or around the horseshoe? I am not, oh, yes, go ahead.
Sorry. I'm not really sure I'm going to word this properly, and it may be a better question for Kathy, but when people in the probate system think about a potential consolidation into the court system, the main judicial branch, what are some of the concerns that you have?
I'm actually going to interrupt that question for a minute because that's a perfect question to launch our discussion after Judge Mitchell. So can you hold that question? And I promise I will remember to call you first.
Sure.
That's a great question and a good way to start our bigger discussion. I think at this point, it probably makes sense to have Judge Mitchell talk with us about guardianships, adoptions, and similar proceedings. You can go ahead.
Thank you very much. And as you've heard both from my register and from Judge Avantaggio, guardianships, et cetera, are at center stage of much of our court time. As a matter of fact, I wanted to share with you my calendar for tomorrow, so you'll have some sense of what we're doing in this area. My first meeting is at 8:15, and it goes to the home court rule because I have a pending guardianship and the district court has a protection from abuse hearing. So the judge and I need to talk about the case, and if it is appropriate under the statute, then the district court judge will issue an order for my files and I will send them over. And frankly, I can't think of a time when that hasn't happened. The problem is scheduling here because the district court judge has a hearing on Thursday on this issue. And our court tried diligently to work with the district court, and everybody was so busy to get a time to do that. Is sometimes challenging, but it needs to be done, and it makes no sense. I think the home court rule makes perfect sense. To have people in two different courts is not very good. So that's my first item of business. And I'm just going to go down the titles and talk about when they have an attorney even. So my first one is an adult guardianship review of emergency removal of a guardian or a temporary appointment. And there are attorneys involved on both sides in that issue. Second, guardianship and adult final hearing. Next, termination of adult guardian. And I must tell you, those are the most rewarding days of my sitting on the bench when a guardianship is always intended to be temporary, whether it's for a minor or for an adult, because there's always the hope that it's no longer needed. And when someone can come into court and demonstrate under the law and under the evidentiary rules, if I'm a minor, mom is our dad. Now, okay, biological parents, mom and dad are able to take over their responsibilities, which they temporarily relinquished. Secondly, sometimes an adult. In fact, I have one person, this is what an emergency guardianship is about, and I know both Judge Avantaggio and the judge from Oxford County, Judge Crockett, can tell you that they're called anytime, day or night, to deal with an emergency guardianship when I had a father who went into a coma, was totally non-responsive. He was a single dad, homeschooling his kids. Grandmother was waiting in the wings to take over, but clearly everyone hoped that that was temporary, but it had to be done then, ex parte. But then you have the hearing, and fortunately, this gentleman has recovered and has you end that guardianship immediately, which everybody pulled for. Then I have a TPR, which I must say, a termination of parental rights, which is the bane of my existence. There's nothing I dislike more sitting on the bench than terminating a parent's rights. And of course, it sort of goes to the issue of all the things that are underlying, whether it's wills, trusts, estates, or guardianships. The due process issues are front and center for all of us every single day when we get on that bench. Then I have the conservatorship of a minor. I have that today. This is all tomorrow. And then finally, I have a 2-hour hearing on an adult public guardian and conservator. So let me start just a moment with the minor guardianships. And you know all of this by statute, so I don't want to repeat anything. But before I do that, I want to tell you that I have the best job in the state concerning probate because I have Kathy. So, and so I also want you to understand that it's not something you can snip the cord for, because Kathy is like my paralegal. She's my guide. She knows the history, and I work with Kathy. I have no clerks. I have no interns. I have nothing. I have the internet. I can call my colleagues, which I do at all times, but there is a relationship between our offices, which is, I don't even know how to describe it to you, but we totally work together. Should this be informal? Should it not? Or has all the note? They put this calendar together and we talk about how much time it's going to take, everything from scheduling to the substance of the issue. But you can do an ex parte emergency order for a minor only in really rare cases when there's the safety of the child is so much at stake that you can't wait. But if the parents object, you have to have a really quick review hearing, but you always review these emergency ex parte. I'll give you a couple of examples that came in Kennebec because I think examples sometimes help. We had parents who were killed in a car crash, both parents. And so we had to do something on an emergency basis, but that doesn't always work out in the thing. This is why all the safeguards have to be in place. There has to be follow through. So both grandparents stepped up. They decided they'd divide the responsibility for being the guardians of this minor. But it turns out one later decided that she wanted her son to adopt those children. And only because the son applied to adopt did we realize this guardian had given the children away under her guardianship to her son. So this is still pending. Again, the paternal grandparents had not known, but the complexities of human life are exactly what we're dealing with guardianship. There is no cookie cutter answer. And that's why all these safeguards of due process and notice, and frankly, this issue that, thank you legislature for making us review guardianships that were put out there, because when that has happened, I have discovered things like this. I have discovered the parents are they've moved to another state, or the person has just been abandoned, if you will. Not the child so much, but an adult guardianship. I had another emergency request for a guardianship. Everybody supported it. There was a 12-year-old girl under guardianship who had become so dangerous to the guardianship family that she was hurting herself, threatening to hurt the other children in the home. So we had a hearing, everybody was present, and she went to live with a grandmother in another state. But also that's the other thing you know for minors, if they're 14 and over, we talk to the minor. We're very discreet about that. It's always difficult to know. You have a witness, of course, making sure that, but you want to know how this person feels, because teenagers vote with their feet in many cases, and we have to be sensitive to that. A lot of the minors we get, but more adults too, come from pressure from Department of Health and Human Services. I'm going to segue over now very quickly to adults, and I'll come back to minors if you wish. Often parents will come, well, they stay with minors. Parents will come into court. There will be someone from the Department of Health and Human Services. They have basically been advised you either get a guardian, a suitable guardian for this child, or the child will go into foster care. So we have big debates about that, and we deal with the records and notice and et cetera, et cetera. One of those that happened recently was a couple who had DHHS had found to have put their children in jeopardy. It was a security guard who had failed to put his weapon away, and the 2-year-old fired it and shot mom. She lived, everything was fine, but that's the level of the seriousness of what we're dealing with here. And so, but the idea is that mom and dad hopefully can be rehabilitated in terms of appropriate childcare and safety and that sort of thing. So the idea is just temporary placement. But there is one issue for you to think about. If a child is under the auspices of the Department of Health and Human Services, the rehabilitation track, they have services from counseling and that sort of thing. We don't have those tools in probate court. So once the guardianship is awarded, that's the end of DHHS's involvement. So it's just a thing to think about. What we often do when mom and dad are trying to get back, mom or dad, get their child back, is to, and they're not quite ready, we create a form of transitional service. So if they can demonstrate over a period of time, keeping the guardian there as a safety net, because once you end the guardianship, you have no say. And all of you know, I don't have to tell any of you this, the constitutional right to parent your child is paramount in everybody's view. And so it's not just best interest of the child. You have to deal with the unfitness or the temporary inability of a parent to take care of a child. So with adults, guardianship has always been for all of us, even before these safeguards, with the very last resort. It is so serious to take someone's rights away and put them under guardianship. And so you only, that's why notice is important. That's why counsel is important. So we use a system of court visitors, and they go out when an emergency has been applied for, and advise us, is this an emergency? Sometimes we have to do the emergency even more quickly than that. But nevertheless, the visitor is required to be the eyes and ears and to help us understand the gravity of the situation. And if there's no family member, often we find these things through adult protective services. And that's when the department gets involved because there's no family member available or who can even think of taking care. They're in another state or family relationships are so dysfunctional. So then they'll come to us under the guise of adult protective. Sometimes they're put in the hospital and they're a hospital bed. And so this is why in COVID, I think we all learned about the goods and the bads of Zoom. One positive thing that we can keep going is the ability to keep this person who is under a pending guardianship. They can participate. They can participate from a hospital bed. They can participate from a nursing home, but sometimes they won't. And our standard is they have to be there unless by clear and convincing evidence, there's an excuse not to be there. And also, as soon as they object to this guardianship, we appoint counsel. If they can't afford it, our county pays for it. And so that's another issue, which goes back to the supply of attorneys. I know Kathy Ayers has pointed out there's a shortage. Fortunately, we've always been able to find one. And I want to talk one more thing about the emergency review. When I put someone under emergency review, we really have to come back and review that quickly. Most of the times, and this is the extra work, and I'm not saying it can be avoided, you put on a full hearing, because if you can't keep that guardianship, then it goes away until a final hearing for a petition for a regular guardianship. So everybody comes, and the department in particular will have 2 or 3 hour hearings to decide, is this an emergency? And that's a big question. And only once after all these hearings has an attorney prevailed in saying, no, this isn't. And it was in this case, the individual who had just been unusual in the community was not, she had an apartment, she stood on the street corner and talked about the president of the United States was coming to pick her up, things like that, but she was not a danger to anybody. She had housing, she had food, blah, blah. And so she was put into, she was committed to one of the institutions involuntarily, I believe. And that commitment order also gave the institution the right to administer medications over objections. So he argued she didn't need a guardian. She was safe. They could give her the meds, and he was right. He was right. So I ended that guardianship. I have another very complex case because maybe it's because of where we sit in Kennebec. We deal with Riverview and we deal with Tovis. We had I've never seen this part of the statute in my years, but a doctor at Riverview refused to follow the orders of a guardian, saying it violated all her professional instincts as a medical professional. Well, that triggers a hearing. So we went through many, many things, and ultimately they were arguing over how many milligrams of clozaril you should give. And so I learned through that process that if you're involuntarily committed to Riverview without the permission to give medications over objections, they can only give medications after you decompensated to the point that it becomes a terrible experience. And so that is a huge issue in terms of these involuntary commitments. And I'm going to follow up on Kathy's comment. I'll have a hearing sometimes and I don't know they've been involuntarily committed. If someone tells me, then we can get the attorney who is not the attorney in my court might have the record. So that's a problem. I don't know why they've been involuntary committed. I don't know if they have a right to, do medications. But often, if they don't, they want both a guardian and the involuntary commitment. So that's a fuzzy area which would need a little more attention, I think, as we go forward. Very quickly, the adoptions, we do a lot of step parent adoptions. These are not child protective type things, but they are when one of the bio parents has basically consented or has given up interest or whatever in this child, and the bio parent that has the child has formed a new relationship and a new family, a step parent. Those are step parent adoptions. you'd be surprised at how many adults want to be adopted. So if you're over 18, you can just be adopted if you choose, and you have people who would like to adopt you. And then we have adoptions which are heartbreaking, and a couple of mine have been teenagers who were date raped. They had an infant. They wanted to give this child, and they always have to explain their best interest. They have to get counseling. They have to have an attorney if they want one. So many procedural safeguards that they have, but it's still heart-wrenching to see this as they're giving up their child. So adoptions are there. And name changes, and I'll end with that because it's light. You can't really not do a name change for an adult unless they're trying to defraud somebody. I agonized recently over a woman who wanted to change her name. Her first name was Savannah. She wanted her last name to be Banana. Her name was Savannah Banana. So we dealt with that. She did come in and we talked about it, and she thought it would be fun. But minors' names are different because there's a whole set of guidance that was put in to the statute to help the district court as well as us in determining whether it was in the best interest of the child. But we also noticed both parents, even that absent parent, even so, and it's confusing to the pro se. They think sole parental rights means that the other parent doesn't have any rights, and that isn't true. So we do have attorneys, we do have visitors, we bend over backwards to have all the due process rights protected, but it is still very, very difficult, very time consuming. In Kennebec, and I can't begin to say how other courts do, Kathy probably can better than I am in there for, you saw my Wednesday schedule. We added Tuesday once a month, an extra Tuesday, but I have other days. Kathy has already asked me for extra days for November and December, and she's scheduled out till January. So it is a very busy caseload. I do other work. It is part-time. I do court mediations, and I'm not really practicing law very much, but some of our judges are doing all of these things, and they're doing a great job at it. But at the same time, it is very demanding. And I will just say this about the judges. We just had, you talk about training. Before COVID, we met every January and every fall, the judges. And at our last in-person meeting in January, all the registers met with us. And so it was a meeting of 16 plus 16. And it was, how do we deal with this new version of the Uniform Probate Code? And so there is a great deal of support from one another in terms of education, because we're learning still, I must tell you. And as Will Avantasia pointed out, we carry this book very close or either our computers. And if you don't know, you look it up. And so I'm sorry to go on so long, but last thing, I promise. We're a very form-driven court. And this is another place where the registers are so helpful. This is a petition for guardianship of a minor, and there's one for emergency guardianship of a minor. And you're pro se at that point anyway, you walk into court with all these questions, and who helps you? Kathy's staff. And it's very form driven. Almost everything we have is a form. And so hopefully it's easier with staff members assisting you to get them filled out. Thank you.
Thank you very much. I know that we may have a round of clarifying questions, and then we'll start with Julie Howard's question to launch our discussion. But at this point, I think perhaps we should take a 5-minute break so folks have an opportunity to stretch. And let's see, it is 11:43. So let's return at 11:50. That gives us a couple extra minutes. And we'll do clarifying questions and then our conversation. And if you are participating on Zoom, please remember to mute and turn off your camera. Thanks.
All right, I'll race you to the ladies' room.
There's one on every floor.
Oh, yes, I'm so sorry.
Hi, everyone. I just wanted to let folks know that we're gonna resume our discussion in a couple of minutes and just ask that people return to their seats and also activate your video if you're participating remotely. Thanks. I know. Yeah. Yeah. So we are returning from a little break and we'll start with any follow-up questions for Judge Mitchell, and then we'll launch into an hour-long conversation between Judge Mitchell and Kathy Ayers and the rest of the commission. So let's start with follow-up questions for Judge Mitchell. Any? Wow. Okay, go ahead.
Going back to the legislative days, I can't go without asking her a question of some sort. So I guess one of the questions is a jurisdictional question. I know what I do in my court, but I'm curious as to what I think all the other courts have the same issue. When you have an adult who's essentially been abandoned, i.e. no guardian, and obviously the respondent still needs a guardian, and you find out from a review that the guardian has either passed the way or is taken off out of state, and you have an adult who still needs protection. What course of action do you have? What authorities do you have in a statute to require adult protective services to step in or to take on that role?
If the guardian is deceased and this person is there at one point having been deemed incapacitated and in need of a guardian, I would immediately have a hearing and contact adult protection to make sure our family members out there. And my number one concern is, what's the status of this person? Maybe they don't need a guardian anymore, but we don't know. And so I would convene a hearing, a status conference or something immediately to find out the status of the individual who it may or may not be at risk. What would you do?
My understanding, I've been really fortunate that adult protective will show up if I have my register requested, but I have no authority to direct them to take it on if nobody wants to step in. And
your point is well taken. If somebody needs a guardian, you can't make the Department of Health and Human Services step in. You are the judge, not the advocate, not the attorney. Someone has to petition.
Go ahead, Representative Cardone.
Judge Mitchell, the issue came up with Kathy and you touched on it as well. The need for attorney involvement. And I assume that happens primarily in the guardianship, conservatorship arena. In Kennebec County, anyway, you've said you've been fortunate to have attorneys available for the court-appointed work. So a couple of questions on that. Do you know if that's the case in every county, or are you running short of court-appointed attorneys? And also, are they? I honestly can't remember. Is there a set price, a set fee for court-appointed attorneys across the state, or does each county set what they're paying the attorneys?
I'll defer to Kathy on that set fee, but let me elaborate on my initial comment. We had gotten usually we get just out of law school, fresh, energetic attorneys. And believe me, if you're assigned to advocate for a person who is potentially under guardianship, that's a tough thing because you're taught to be a litigator and your person is in the mental institution and everybody's worried to death about them, but you're at so I've watched them grow as they learn to advocate for the best outcome. Let me put it this way. That attorney who came on a few years ago is now moving. And I don't have a lot of new attorneys because the more seasoned, more experienced attorneys, they're busy and we don't pay enough. And I'm gonna let Kathy talk about the pay. So I am concerned about the pool, and Kennebec is bigger than a rural county like Washington County or Oxford. And I can't speak to them, but they will. But it is a concern to have an experienced attorney. The emergency guardianship that I terminated, I think if the seasoned attorney came because he had a new law school graduate. He was training to come in at these lower rates. He took the case, and because he had been the attorney for DHHS on guardianship cases, he knew how to argue the law, and he ended the emergency guardianship. A new attorney may not have been so expert, so it's uneven. I'll put it that way. It's much lower than a practicing attorney would make. And rural counties, I'm sure, struggle mightily, just as they do in all cases. But I'll let Kathy respond.
We're not part of the main legal indigent services.
I know, yep.
So, and most of these people are indigent. We fall, in Kennebec, we try to follow that, and we've even gone above that amount to recruit attorneys, but it's not so in other counties. But the county does set the rate, so.
Okay, so your attorneys in Kennebec County may not necessarily be getting paid what Cumberland or Penobscot or Worcester.
That's
are
right,
getting
that's
paid.
right.
Okay.
Yes, go ahead.
I can say that we also track whatever MCILS is paying, that's what we pay. And I don't recall that it's $70 or $80 an hour right now, but it did go up recently.
Yeah.
MCILS just went up to $80 an hour. I don't know where that is vis-a-vis what the probate courts are paying, if they're in that range.
There isn't uniformity, and we track that. We also have the ability to assess the estate if the person has it. Sometimes the person has plenty of money and we can let the attorney charge the estate. We just make sure that there's an appointee on board.
Thank you. Go ahead, Judge Puckett.
I would like to reiterate what Judge Avantaggio said was generally most of the counties track what the state rate is. Now, initially, when this august body created the main indigent legal services, it was contemplated that the probate appointments would be part of that. And that's why there's been legislation in the past few years. And this goes back to 2009 when that great Senate president helped pass this whole thing. But yeah, it was always intended, but they're supposed to generally track. Not all of the rural counties have the resources to do it, but that's what they're supposed to do.
Well, one of the, I'm sorry, I know Judge Mitchell wanted to say,
I just wanted to broaden your question a little bit. We try to track also guardian ad litem fees as well as visitor fees and that sort of thing. That was all I was going to add.
one of the reason I was asking, and since you brought this up, Judge Crockett, one of the things that I want us to consider as a commission is what to do about court-appointed counsel. Is it going to depend upon what we do with the probate courts? Probably, but conceivably, we could even say, even if we're going to leave 16 separate probate courts, we could still put court-appointed counsel under the state MCILS umbrella and have the state take over that function. Guardians ad litem at the state level are not MCILS. They're paid the same rate, but they are still appointed by the courts. So I would assume that if the probate courts are moved under the state judicial umbrella, the probate courts, wherever they are, will still be appointing guardians ad litem, but that function will also be taken over by the state.
Sounds like we're all ready to dive into our broader conversation. If there are any follow-up questions, we could just incorporate them into the discussion. Julie Howard, I wanted to invite you to kick off our conversation with the question you had asked earlier, if you would.
Sure. I was curious as to, I'm putting myself in the position of the registrars because that's basically the same job that I have. And I'm curious as to what the concerns are among the probate courts about potential consolidation with the judicial branch. What are your worries, and what do you hope will come out of that? I guess maybe that's a separate question, but I'd like to know what the concerns are.
I think, of course, the job security is an issue for some people. I also think that I think the job of tracking adult guardianships that we have to do now is a really large bite of the apple. And these status reports now for each guardian have to be taken in, sent to interested parties that can have notice, and then the judge reviews them. And the judge sometimes finds problems with them, of course, and will have us, and the biggest one for us with adults is people move and they don't tell the court where they've moved or where their ward has moved. And that's come to light with the new probate code and us tracking them. So the system for tracking, I'm not sure what my hopes are. My hopes are that we can still give the people the service that they get at the probate courts, because for me, helping people is the best part of your job. I mean, it's the only real part of the job that counts. At the end of the day, you go home and you say, wow, I helped this person. I helped this little old lady fill out these forms so that she can go to the bank. And in COVID, it was really hard because I couldn't hug people or pat them on the back. So I think that's the thing we all want to carry forward.
Go ahead, Judge Crockett.
So the assembly, the probate judges assembly, which today I'm the designated spokesperson, I guess, for, we had a conference this last weekend, and we had our CLEs, our continuing legal portion for judges. And then we also discussed this issue. And so the issues that we foresaw, and Judge Mitchell and Judge Avantaggio can jump in and correct me if I'm wrong on some of it, but some of the other issues that popped up were more technical in nature, like the e-filing systems. I know that when we did the moral obligation bond initially in 2013, 2014 on the judicial branches filing, it was always kind of thought about. And I know that one of the leads on that committee was inquired whether the judicial branch was going to have some way that we could dovetail our system into it. And I don't think that initiative died. And obviously the judicial branch is still working on their e-filing system. So there's the integration portion. That's part of it. Also the transition of turning over records. In terms of cases, the flexibility and the timing, because probate courts actually haven't fallen behind with COVID for the most part. We've had a little better circumstances because we have more flexibility and less cases in the district court, which is where the rubber meets the road. And I understand the caseload there. We also, because we have part-time judges, we have flexibility in scheduling, which is a real advantage. We also have time to contemplate decisions, and we have a little bit more writing time than what the district court has. We also would be worried about losing that regional familiarity. In Title IV, the district courts have certain regional appointments, familiarity with different demographics across the state. They're supposed to be, we appoint district court judges sometimes based on where they're at. And we want to make sure that's not lost in the translation, whatever plan were to come about, because there's a certain amount of advantage to understanding the area in which you are and the credibility that comes. It's a little bit different when you're a probate judge, or I'll use a great example. When you're Jim Mitchell sitting in on a case who's been there for 30 plus years at the time, when he rendered a decision, people had a great deal more confidence in the decision because there was a familiarity with the person and a certain gravitas to the position. And that's part of the law. That's why we wear robes and so forth. But that sort of regional familiarity, that's whatever plan that comes up with, it needs to be addressed, whether we do similar to what the district courts did in Title IV, or you create probate districts or whatever. The timing of files, right now, we understand there's backlog in the state court. I don't think that's a surprise to anybody. We want to make sure that the responsiveness for the reviews and the flexibility for the judges. I've had hearings not in my courtroom. By statute, by under Title IV, probate judge, the court is wherever the judge is. In fact, we're authorized a whopping $5 a day for travel, for whatever that may be. And it goes back to the old circuit theory with probate judges had counties, and I have a county that's the size of Rhode Island, right? So you can, well, not quite, but pretty close. You have flexibility. So those types of issues need to be addressed. And I think in terms of, that was some of it, and I'd let Judge Mitchell jump in on some of the other, the other portion was the gathering of information. In order to come up with our roadmap that we're going to need to get a solid plan together, there's certain information that this commission is going to need from each of the county courts. In great examples, in 1967, then Attorney Cohen, now former Secretary of Defense Cohen, went around the entire state and met with every probate judge, with the exception of Judge Bellevue in Oxford County. So he met with 15, he interviewed all of them, and they collected data. We don't have that kind of time, but there should be some questionnaire that goes out to the registers to get an idea what our caseload is, dockets, a pro se amount, and any collection we can get from the bar in terms of information and concerns they may have. But the problem is in probate courts, 50% of your people don't belong to a bar. So that's where the registers and any questionnaires to them directly would be so useful. But that's a shotgun blast. So if you want to elaborate.
Yeah, that's extremely helpful. And we're actually going to spend some time in the last hour of our discussion today brainstorming about additional information, especially the data element of it that we want to try to gather to make sure that we have that available as we proceed with our process. Go ahead, Representative Cardone.
Just to follow up, when we were talking during the break, Kathy Ayers came up with a great idea, and I'm not sure who the appropriate person is to look into this, but she suggested that maybe the vendor, Icon, could provide that information to us at the vendor level, because to the extent that it's connected through a system, Icon would be the one who would be able to get it to us. So I'm hoping that, and I don't know whether that's our analysts who can look into that, or whether we need to contact somebody in the probate court system, but I'm hoping somebody can address that with the vendor to give us a response there. That'd be Kathy. Okay, just remember, you suggested it, Kathy. That's right.
Let's hang on to that thought and revisit it later this afternoon. But with regard to Julie Howard's excellent question, I'd like Judge Avantaggio, could you please answer the question, and then Judge Mitchell will ask you as well.
Sure. My concerns would primarily be two, and that would be, well, same concern, two different areas. That would be that we lose what I think we do best. One would be that sort of customer service area that Ms. Akers had talked about, that the amount of sometimes literal hand-holding that goes on in the front office with a widow, somebody whose child is in the hospital, any of these circumstances, to help them get the forms correct before they come to me, so that I don't just say, this isn't done right, I can't act on this, is impressive and beyond the level of what a district court clerk has the time or really the ability, given the space that they work out of, to do. And the other is the nimbleness with which we can move. When I'm in a pretrial conference, I had a case recently with a child was 14. Mom had given a guardianship paper to her husband, whom she had known for 7 months, been married to the day before she reported to prison for a 3-year sentence. And the child did not want to be there and left and went to grandma's house. And grandma had filed a guardianship, but no papers in place, couldn't register the child in school because she didn't have authority to do that and didn't live in the same town. And so we just pulled out a calendar and I said, okay, next Wednesday, can't do it. Tuesday after that, what do you got? And carved time out of my schedule and knew then when we could do it and got it done just so much more rapidly than the present circumstance of the district court or the superior court allows. And that's, I don't know that the superior court or district court system is wrong in that. It's just processing so much information. So one of my concerns is that both systems get less effective by incorporating this system. I think that can be dealt with, but I want to make sure that we're aware of that. That, you know, as I sit here, I and my registrar are elected to serve the citizens of this county, and I want to make sure that they're as well served, at least moving forward, as we try to figure out how to integrate them into the whole.
Thank you very much. And Judge Mitchell, did you want to answer the question as well, please?
I'll just echo briefly because you've heard it from the 2 judges so far. I don't know how you can find a substitute. We really have to think about it for the customer service on what you have called the back end of the court. And because when people are before us under our limited jurisdiction, they are very vulnerable and need help. And I look at the different courts, you can walk in and there are people like Kathy in all the courts who want to help you with these forms, which moves things along, but they also feel heard. No offense at all to the Capital Center District Court, but if the clerks wanted to help you, I don't know how they would, because they're sort of behind this glass, like you're at a movie theater and you talk through a little opening, but it's not the same thing. So how do we preserve that and maybe help the district court improve? They probably would like to do it too. So it's not insurmountable, but it is absolutely critical. It's distinctive to the probate court because of the way we're set up. I think that's extraordinarily important. And all the other things the judges have mentioned are as well. Nothing is insurmountable, but it's important to recognize that as we move forward.
Thank you. I'd actually like to raise that same question to those who practice in probate court, to the attorneys who are practitioners who are part of this commission. If you could share with us your concerns about what the transition would mean. Any volunteers to go first? Go ahead, Tudor, go ahead.
Hi, sorry, I'm so slow with my unmuting here. Yeah, I also practice in Massachusetts, and I have to say that dealing with the probate courts here in Maine versus what I encounter in Massachusetts is vastly different. And I view Maine's as much better. Just kind of the level of friendliness that you get when dealing with the court really makes a big difference. I mean, every attorney makes mistakes from time to time. There's, a little tiny box that doesn't get checked, and the response from the probate courts, and this is consistent throughout the counties, is always very non-judgmental. It's always very friendly. It's just, oh, hey, do this. Okay. In Massachusetts, I mean, just by way of example, I mean, if you don't file documents in the proper order, which is nowhere in the rules or anywhere, they'll reject it and just do it again. And it's just very different. And I would just definitely not like to see the kind of administrative burden grow, because for a lot of people, they're trying to do things cost effectively for their clients. And, obviously we want things to be time efficient for the court as well. And I think in general, the courts have done a really good job of letting practitioners know what needs to be done, but overlooking the small stuff at the same time. And I just wouldn't want to lose that.
Any other practitioners have anything to offer? Can I put you on the spot, Representative Cardone?
Yeah, I don't have anything in addition to offer. All of the things that have been raised, I agree with. There is something I'd like to ask Julie Howard, and Julie, you don't have to answer this today. You may have to, no, I mean, you may have to think about this, but we'll talk about this a little later. As we move forward, there are several models that we can look at and choose from, or maybe we pick and choose from, but we're going to have to put together a model. Something that I've been struggling with and that I would like to know is, Julie, do you see any way that we could integrate a registrar's office with all of the customer-friendly things that they do with a working clerk's office? And as the district court works now, is it even possible to mesh these two things together? Or are we looking at keeping two separate offices, a clerk's office and a probate registry office? And I know there's going to be the technology issue, but I'm talking about more from a functioning workload, how we manage cases, how we interact with the public. The answer to that question may determine, at least in part, which model we adopt. So I'd really like you to give that some thought. If you don't have, if you can't answer that today, that's fine. But I'd really like to hear from you on that.
Sure. I mean, one of the things that I've done every time I've started a new job, for example, is I don't want to change anything when I get in there. Like if it ain't broke, don't fix it. So, I mean, when I envision this, I would, well, first of all, there's no room in the district courts to put anybody else, but at least in my district courts in Region 1. But I guess, and I'm just kind of thinking out loud, but I wouldn't want to mess with what is successful about the probate courts. So I can see sort of an administrative, as somebody referred to it as an umbrella, but I think that could be done in sort of leaving things the way that they are in many ways. So, and I just want to be like Kathy Ayers when I grow up. So, I mean, we want to be more like that. So those are some of my initial thoughts. But obviously we're a committee and we'll figure it out and we'll decide what's best. Those are just some of my initial reactions.
Okay, please weigh in. I know when we were crafting the resolve for this, I specifically wanted a district court clerk on the committee to give us, on the commission, to give us the expertise, looking at this from the inside out, to give us the expertise in that area as to, what's going to work. We don't want to create a dysfunctional clerk / registry by trying to consolidate something that just isn't going to work. So, thank you.
Okay, I'll think about it some more though.
Other comments, questions that can generate some discussion? I have a slightly provocative question. That's our family Thanksgiving dinner. Like, so there's one of our children who always asks the provocative question that gets people excited. So I can throw that out if others don't have questions. Okay, it's not that exciting actually, but in thinking about it, some issues have been raised about overlapping jurisdiction and coordinating. And I'm just wondering if both practitioners and those involved in probate and district court can brainstorm a little bit on, are there subject matters now that go to the probate court that would actually be easy to integrate into the state court system and that don't invoke so much the customer service aspect that it sounds like we all really value? Like what are the things that would be pretty easy to merge. Nobody likes my provocative
Did you
question.
say easy?
Relatively on the scale, well, yeah,
I'll give you the
okay,
easiest.
go ahead.
Now, this isn't going to be easy, but it is the easiest of all the jurisdictions because the adult protective stuff is going to be completely foreign to the district court because they don't really do it. The wills in the state, so forth, that wouldn't be easy. Name changes, you could easily take those. That could, it would be a joy, and I'm sure the district court has plenty of time, so they could handle those. That's the easiest. The second, and this would not be as easy because it would put the department, and I do some stuff with the child task force. It would put the department in a strange spot, but our guardians of minors. But the problem is once you go to district court, the way you approach a guardianship of a minor and the permanency piece is completely different than the way the probate courts approach it, because our goal is reunification and it's all consent driven, and the goal is to get the child back, and that can take shape over like 5 or 6 years. I'm not sure if the district court has a lot of guardianships that are in existence for 6, 7, 10 years for a minor. They're not supposed to. So that would be a big shift. Well, not a huge shift, but it would be a partial shift for the district court. But the name change is the easiest. And then the second is the children.
Judge Martin, did you want to respond?
I would agree with the guardianship of the children. I think that I mean, the district court is busy. It is a busy court. It's busier more now than ever. However, it seems to make sense that any family matter issue with respect to the children should be part of the district court. It doesn't seem to me, I mean, I can honestly say that I've probably had 3 conversations with probate judges to transfer any guardianship over to the district court since I've been on the bench. So it's not happening a lot, but it's certainly something that I think the district court can absorb. And I think it makes sense to have those things in one place.
Representative Cardone?
If we were to take that course, and I was thinking along the lines of the children as well, if as being maybe the first step in a jurisdictional integration. If we were to take that step, would we also include adoptions in that first move? Everything having to do with minor children? I think as a matter of fact, if you've got a guardianship of a minor child under the home rule, you're going to have the adoption anyway. Should we move all adoptions there also? Or should we have adoptions a split jurisdiction?
If I can answer, I would include the adoptions. I mean, I think there's these fingers that come out of all these cases that pull things back. Like for example, if there's I've done a number of adoptions. Those are my favorite things to do as a district court judge. I can't, I mean, to take those away from the probate court, I don't know how you feel about that, but I'm doing those because they're consistent with the department's termination hearings. So we've done quite a number of them. But it makes sense, again, to have those in one place as opposed to, picking and choosing on where those take place. So I would include adoption. Any family matter dealing with children, I think should be in the one area.
Kathy, did you have your hand up? No. Okay. Are you going to respond? Okay, go ahead, Judge. Okay, go ahead.
In response to that, there's an ideological part of me that completely agrees with the concept. The practical part is where we come into an issue, is that I've seen both. I've seen it in district court and I've seen it in probate courts. And I don't think many of the district courts have ever, many of the district court judges of all have ever seen a guardianship of a minor in a probate court. And it is handled entirely different. And the legal standards is still observed, but the way you approach it, because the theory is that you're trying to get a temporary situation. Think of a soldier deploying. You get someone who's a prisoner of war for 5 years, right? That guardianship is not meant to terminate that parent's rights. It's a continuing piece. And sometimes there's change of guardianships and there's conservatorship that goes along with some of that. If you have minors assets or you have an adult assets and how it ties in. That's why the probate courts were historically called the courts of widows and orphans, is because there is an integration of the two. You would have to take on conservatorships that impact that guardianship as well. And that'd be much greater expansion than what the 1961 law that created the district courts contemplated. And if you think about the home court rule cost us 2 or 3 million when that was passed, this would cost, I can't imagine the exponential amount, because the number of open minor guardianships across the state that the judicial branch, and this is why ideologically I support the idea, is that the judicial branch right now can't tell us how many people, how many children are under guardianship, because they don't track what the probate court does. And no matter what comes out of this commission, if we can't do it, there needs to be some sort of tie-in, because it puts the judicial branch in a really awkward spot where they're supposed to have oversight of all the courts and of these types of cases. And I think and I don't know what their official position is, but I can imagine it would irk me a little bit if I were responsible for these and I didn't have a grasp on what all the probate courts in the state were doing. So that's why the ideological part agrees with you. The long-term practical part says that would have to be done over time. And I'm not sure if I would take a chunk out of it right now, but I think the idea is to get the track going in that way.
Thank you. Judge Mitchell and then Tutor Goldsmith.
My comment really has to do with our concerns keep evolving as, well, yes, it's a good idea, but the district court does X and maybe that isn't as effective, whether it's the customer service of our clerks versus how they're set up and how we're set up. We had an email which will be shared with you from an attorney who does lots of private adoptions, not the kind you were talking about. And he talked about the delay, not blaming anybody, but the district court schedule is not as flexible as ours. And that's an impediment to newly born children. These are private adoptions, not with. So those are issues. And maybe we need someone weighing in from district court administration as if you're going to integrate something, if the problems are, well, we do it one way, which we kind of like, maybe they could meet us somewhere and change their process. I don't know, but that has to be considered to graft onto them system things that we don't want changed and ask them to say, it's okay to go your way. It's not working. You need to have a conversation, I think, with district court administration.
Thank you. Go ahead, Tutor.
Thank you. So I was once involved with a minor guardianship that I initiated in probate court on behalf of a grandparent with the mother's full participation and consent. And the father had not been involved for this child's entire life. He was almost 5 years old, zero involvement. And we had a number of different notices, hearings. He was no show every step of the way. And we were on the verge of our final hearing. And he, at that moment, filed something in district court. All of a sudden, jurisdiction disappeared. Now we're in district court. And we are right back at step one because of all the due process concerns. No judge, no district court judge that's taken on a new minor guardianship case wants to rely on no-shows and notes that they've taken in a probate court because they're not the judge. They're just not going to rely on that, and I wouldn't blame them. But it does invite a bit of potential for abuse. I mean, all things told, this minor guardianship should have been over and done with within a few months, and it ended up taking a couple of years. It cost this grandparent who's going out of his way to take care of his grandson, cost him a lot of extra money because he just had to keep showing up at hearings, keep watching this father no show. And so I do think that there is a potential issue with that shared jurisdiction, and more specifically with how quickly the jurisdiction changes in a situation like that.
Thank you. Justice Gorman?
Yeah, so I was not part of the political process that created the Home Court Act. I was part with Judge Libby, Judge Libby Mitchell, to make sure that it worked on the ground. And we were aware at the time that this was a compromise at a time when lots and lots of people were suggesting that family cases should not be handled in two different court systems, and elected to move them to the district court if certain parameters were met. If we're going to be talking about moving all of the family cases from probate court to the district court, one of the first pieces of information we need is numbers. And as Judge Crockett pointed out, we don't have numbers from the probate courts, so we don't know what we would be getting into. And we don't know whether there would be a need to augment the number of district court judges or magistrates to handle any increase in the docket. Yes, we have backlogs. We are doing everything we can to get out of them, but we do have backlogs because we are 5-day-a-week courts, and our judges were unable to be in court 5 days a week, nor could we require people to come into the courthouses 5 days a week. So yes, we have backlogs. I'm not suggesting that we should not be considering transferring all family cases to district court. In some ways, that would make perfect sense. It allows for the original jurisdiction of the probate courts and trust and estates to stay with the practitioners and with the judges who have that level of expertise. Again, I agree with Judge Crockett. It would be a steep learning curve for virtually all of our judges to figure out trust and estates at this point. Many of us just barely remember that from law school. But that being said, I'm a little nervous about us having premature conversations about what would be best without having the data to indicate what kind of an effect that would have. So I'll just raise that red flag on behalf of the judicial branch.
Thank you very much. And again, we'll close our day with a discussion of what information we feel like we need and how to get it. So that's an important point to keep at top of mind. Other comments, questions? I don't have a second provocative question to offer. Does anybody else? Pardon me? Okay, go ahead, Julie. Thank you.
I kind of, as I'm listening, I'm kind of going back to my original theme, which I feel like we don't have time to make those kinds of decisions on jurisdiction. And if we're going to incorporate the probate court into the main judicial branch, I guess I would not change anything yet, but put it, so just bear with me, put it in the judicial branch, figure out the sort of the logistics of finances and all that kind of stuff. And then over time, have some experts look at, okay, what court should this be? Where should the jurisdiction be? And because I feel like 6 weeks or 5 weeks that we have is too short a time to make those huge decisions. And the implementation is also huge, but so I just raised that concern.
Thank you. Other comments, either in response to that or in general, in response to our conversation and the great information we've had about the front and back ends of the probate courts? Go ahead, Judge Crockett.
Madam Chair, I'm going to throw out a provocative question to the chairs. And I know that at the end of the day, we're going to talk about our steps going forward. And I'm wondering what kind of screening criteria for potential courses of action we would have. And the reason I ask that question is because we could spend easily 5 meetings talking about jurisdiction and child and where the minor should go and what kind of case. Or we've got several reports. I mean, some of us have been dealing with this for a decade and a half, 2 decades, right? We've already war gamed this out. There's been 3 or 4. If there's, yeah, well, but personally, between the legislature and the courts, I'm dealing with this for a long time. My old partner was the judge before me and so forth. And obviously Judge Mitchell and I supported this commission when our testimony, we think it was the right thing to do. Are the chairs willing to put forward potential parameters in our thinking? What I mean by that is there's always been 3 general courses of action. One was complete integration. And we do the jurisdictional piece, we shift everything over, complete integration right now. One was a more gradual probate district, leave the registers in place approach, and then try to figure out the funding. And that was viable, but it never really met. The Futures Commission has talked about it, even back to the 1967 Secretary Cohen's report talked about it. And then there was the do nothing, let the old tractor continue to run on baling, twine, and rubber and duct tape. And so those are 3 options that we've always had. And I didn't know if we're going to scale down to sort of pick a course, or if the commission has that. And it's to the chairs. I offer it, and I am listening to.
I've given it quite a bit of thought. Let me see if I can answer your question to the extent that I have an answer. In talking about what we can do in 4 meetings, Senator Carney and the OPA analysts and I have had the conversation, and what we would like to be able to do is vote at the beginning of our 3rd meeting as to what type of plan we are going to propose going forward, so that we've got essentially the balance of 2 meetings to write the specifics of the plan. We got to make a decision before then. Not a lot of time, I agree, but we have to do it. Now, within that plan, we might say we do this much now, and we extend this commission, or we ask for something else to look at this in 2 years and then take another step. And we can do whatever we want within that plan. One of the things that I'm very concerned about, and one of the reasons that we may have to do things in shifts or steps over the years, is that the governor has said to us, although she supports this commission and supports this work, this is not going to be a top priority on her agenda. So if we come in with any single bill with a $50 million price tag, it's not going to get passed, which is why I don't think that a plan that lock, stock, and barrel takes everything from the probate court, including the registries of probate, takes everything from the county umbrella and puts it in the state umbrella on one fell swoop, will have a chance of passage. I just don't think we'll have the finances to do it. I don't think we'll get it past the legislature. If we get it past the legislature, I'm not sure we'll get it past the governor, assuming it's the same governor. So I think that we have to take all of these ideas, all of these concerns with the good ideas that we have to see what we can fashion. Beyond that, I don't have any specifics. We're not going to say, no, we're going to allow this, and we're not going to allow that. This is up. This is a democracy. We each all have one vote. It's up to the commission. Have I answered the question?
Madam Chair, you have, and I appreciate the realities of the circumstance. And it seems like we just want to affect whatever positive changes we can do in the most economically expedient manner that we can. And try to maybe set a course that we can get that long-term solution and just take the progression in small steps. And that seems like it's the guidance from the chairs. So we'll look for those small fixes as we go. Okay, that makes sense. Thank you for the clarification.
Actually, and I would just like to add that I know that many people in this room have a lot of experience with all of the work and research that's gone into this, but for some of us, me in particular, I, as an attorney, have done a little bit of work in probate court, but not much. And so a lot of this information is new to me. And so I think we're bringing a combination of what's been done in the past and a lot of expertise and also some fresh eyes to the problem. And so I don't think we can kind of preordain what's going to emerge from this process. Any comments, thoughts, questions? Would anybody like to, so we've got a couple of minutes before we were planning to take our lunch break. And so I guess I'll do a last call for questions or additional information related, particularly to this, the front end, back end of the probate courts and all of the unique things about that system that are things that we're going to have to really focus on as we move forward. Sounds like perhaps an early lunch is in order then. Okay, great. So we're scheduled to have a lunch break now until 1:30. And then when we resume, we'll hear from Professor Deidre Smith, and she'll talk a little bit about past efforts to restructure the probate court and give us some comparisons from other states that will give us a little more information to move forward. And so with that, just a reminder to please disconnect or mute and turn off your audio, and see you all at 1:30. Hello, everybody. It's 1:30, and so we're about to resume our work this afternoon. And what we've got on the agenda is a presentation from Professor Smith, and then we'll have a practitioner panel at 3:30. And then from 4:30 to 5, we'll discuss our next steps. And so let's see. I should activate my video. And Representative Cardone, would you like to get your video up and going as well? All righty, and has Professor Smith joined us? She has. So as we get started, I'd like to extend a very warm welcome to Professor Smith. And Professor Smith, I think you're going to give a presentation and then we'll have some questions and answers. Do you prefer people to hold their questions until after your presentation is complete? Or would you like questions as we go?
I think what I'll aim to do is maybe pause at sort of parts where I'm transitioning and parts of the presentation to see if there are questions so far. That was my plan. So I will try to remember to do that. I think that might work most efficiently.
Great. And if you can just let me know when you're going to ask for questions, and because we're looking at people and screens and everything, I'll be happy to call on people for you if that works for you.
That sounds great.
Okay, and then I think we have some physical handouts that you've provided as well. And if you want to just let the selected states comparison chart. So if you just know that we have that available if you'd like to refer to it. And with that, we'll turn the floor over to you, virtual floor over to you.
Wonderful. Yes, I wish I could be in person. I've just come from teaching evidence class. So I will be talking to you from my office here in Portland at Maine Law. So good afternoon, Senator Carney and Representative Cardone and distinguished members of the Maine Commission to create a plan to incorporate the probate courts into the judicial branch. It is the aim of my presentation to you this afternoon is to provide some context for your work. So my plan is to provide a very brief history of Maine's probate courts and the overall development of Maine courts in terms of both constitutional changes and those by the legislature. I'll provide some brief background of the studies and the proposals to change the probate court that I know have been provided to all of you by the staff. And then I'll try to summarize some of the key concerns and points that were raised in the reports. And then based on that background, I'll provide an overview of some of the questions the Commission will likely need to consider. I'll talk a bit about some national trends with respect to probate jurisdiction, examples of how other courts, other states have structured the courts to hear probate matters, and some recent reforms, particularly in New England states. And as I said, I will do my best as I'm sort of moving from one part of the presentation to the next to remember to pause for questions as we go, but then also to leave some time at the end for general questions. So you're welcome to hold your questions for the end, but if there's something that you really want to ask before I move on to another topic, by all means, I want to provide an opportunity to answer all of your questions this afternoon. And the other thing I would say is that if I offhand don't know the answer to your question, but it's something that I can track down and get back to you, I will plan to do that and provide that information to the chairs and to the staff. I thought I'd start out by just telling you a little bit perhaps about myself and why I got interested in this topic for those of you who don't know me. So I am on the faculty of the University of Maine School of Law, and my primary teaching since I joined the faculty 18 years ago has been in the law school's Cumberland Legal Aid Clinic, which is where student attorneys provide legal representation to individuals in courts throughout Maine. And that includes state courts and probate courts, agencies, federal courts, and so forth. And when through that work, I supervised students who had several matters in county probate courts, mostly minor guardianship matters. We were representing either petitioners or parents who were the respondents there. But we also did some contested adoptions with termination of parental rights as a matter, and as well as some adult guardianship matters, some state disputes and so forth. And when I joined the faculty 18 years ago, my practice had been in general civil litigation and superior court, district court, and federal court. And I was relatively new to probate court matters. And I was really curious about why it was that these matters involving children and custody of children and rights with respect to children were being heard in county probate courts as opposed to the family division, which is what I was accustomed to, and also why the probate courts were not part of the state court system, and why probate judges were treated so differently from other judges in Maine in terms of being part-time, being able to practice law, and being elected. So I went in search of the answers to those questions. And what I found was a really intriguing story. And that's really the story that I plan to share with you in very summary form this afternoon, because I really found that to be very curious. So I'll start out by just providing, again, just the briefest of history of Maine's probate courts in the context of the development of Maine courts generally. So Maine's probate courts are, in a sense, the second oldest courts that we have here in Maine. The original court that was created by the Maine Constitution in 1820 when we separated from Massachusetts and achieved statehood. The original court, of course, was the Maine Supreme Judicial Court, and that was the one that was enumerated in Article 6. And the legislature was given the authority in Article 6 to create all other courts in addition to the Supreme Judicial Court. And that model was very much borrowed from the Massachusetts Constitution. So other than the Supreme Judicial Court, all other courts are statutory. And over the past 200 years, the legislature has created and abolished many courts. And The other provisions in Article 6 apply to other state courts and sometimes to the probate court with some carve-outs. The Maine legislature organized the probate courts right from the start in 1821, right after Maine's founding. And of course, because we were part of Massachusetts, we already had a system of courts here in Maine, physically located in Maine. We had a system, Massachusetts's model was to have county-based courts, and they actually had that model from 1691. And initially, those county courts had very broad jurisdiction. Eventually, Massachusetts created separate probate courts, one per county. And that was the model that we had when we were part of Massachusetts. And we continued that model when we became an independent state. So we continued to follow that model of having county-based with one probate judge, one register, and a court of special and limited jurisdiction. And while the Supreme Judicial Court justices were riding circuit around the state and hearing appeals and hearing trials, it was important for residents to have someplace local, someplace county-based, where they could go for assistance when a family member died, for administration of that. So it was important to have those courts accessible, and that's one reason why they were created by Massachusetts to be county-based, and Maine thought that was a good idea to maintain that. So that people wouldn't have to travel so far to get the letters of administration that they needed to administer estates. And probate judges were appointed by the governor, and they really sat as the deputy, the designee of the governor for issuing those letters of administration. And the register's function was to maintain the records and to conduct the clerical work that was necessary as part of that. And that original structure, it was created 200 years ago, really has not changed since it was initially created. It's very much the same. I'll note a few constitutional developments along the way before getting into the legislative ones. So in 1855, there were several provisions that were in the Constitution were amended that had an impact on probate courts. And one was to remove probate judges from Article 5, Section 8, which is the section about what nominations, what appointments the governor would make. And it provided that the governor would appoint all of the judges of the state. So in 1855, there was a carve out for probate judges as well as municipal and police court judges. So their manner of selection was going to be for election by the county. And there were some other changes, also the election of sheriffs and a new process for the election of the attorney general. And in his 1952 report, County Government in Maine, Professor Dow, I know you have his report, and he observed, he thought that the spirit of Jacksonian democracy was behind this change to make the direct election of a number of these officials, was to decentralize the control of the governor and make it more localized. And so a new provision was added to the Constitution that's now in Article 6, Section 6, that provided for the election of probate judges and registers. And in 1875, the Constitution was amended again to take out the election of the other court judges, so the police courts and the municipal courts, and to resume that they would be appointed by the governor, but they left the probate judges and registers as being by election by county residents at that time. There was a proposal in 1875 to reconsider it, to take the probate judges and registers out, but they were left in place at that time. And I'll just skip ahead in terms of constitutional developments to 1964. 1964, there were further amendments that really reorganized much of Article 6, which again concerns the judiciary, and removed any reference to municipal and police courts, because by then the legislature had abolished those courts as part of its overall court consolidation, which I'll mention in just a moment. And it did not, the amendments at that time did not address the probate courts. And the reason for that was that the Maine Constitutional Commission in 1963 unanimously recommended that probate judges, but not necessarily registered, but probate judges be appointed by the governor. And their reasoning was, and I'm just quoting from their report, These judges, with the complexity of their work constantly increasing and with the office of the judge of probate becoming more and more important in the main judicial system, they should now be appointed by the governor as our judges of the Supreme Judicial, Superior, and District Courts. But they removed it from the amendments because, unlike the police and municipal courts, there really needed to be a plan for what was going to happen with the probate courts. The language they felt just couldn't be removed. So there needed to be sort of some other model for probate courts, in addition to changing whether they were full-time. If they were full-time, how many were needed? There are a lot of questions that really need to be answered there. And as I'll mention in a moment when I review the studies, that led to some studies and ultimately to the 1967 amendment, which, as you know, repealed Article 6, Section 6, which provides for the election of judges and registers. But it suspends the implementation of that until another system of probate courts is created. So that's sort of the gist of the constitutional developments there. The probate courts and probate judges are dealt with and addressed in the statutes at Title IV, Section 7, Article 7 rather. And so there's quite a bit of detail in there about probate judges and so forth. So there's certain things that the legislature can do, but ultimately, as we'll see in a moment, they were a bit limited in what they could change about the probate court structure because of that, of the language that remained in the Constitution. And so over this 200 years, the probate court's jurisdiction itself has remained the same in many ways, but has also changed in many important ways. The basic structure hasn't changed. And of course, it still has the jurisdiction that we associated with it in terms of, wills and grants of testamentary or administration of the estates of deceased persons and so forth. The general jurisdiction of the probate courts is in Title IV, Section 251. But some of the significant developments over the past 200 years, one of them certainly is the enactment by the legislature of the Uniform Probate Code, which became effective in 1981, which really changed in so many significant ways all aspects of the probate court's work. It established much clearer criteria for many aspects of their jurisdiction, and many other changes about the role of the courts, the function of the courts in the administration of the states. And the other thing that's changed quite a bit, or one of the other things that's changed quite a bit over the past 200 years, is the role of the probate courts with respect to family matters. Obviously, it's had jurisdiction over matters involving children. It's been an important part of their probate jurisdiction from the start because minor guardianships have been part of what probate courts have done since 1821. And 1855, Maine established adoption, legal adoption, and that became part of probate court jurisdiction. And then separate provisions for name changes was part of their jurisdiction. At various times throughout the late 19th and early 20th century, probate courts have had and then lost jurisdiction for things such as desertion and non-support and separation. They've had some role in child protection matters, such as issuing preliminary protection orders and so forth. But notably, the changing statute with respect to minor guardianship, particularly since the enactment of the Uniform Probate Code, and the changing use of minor guardianship has really led to just an explosion of those types of cases. So it has become a more significant part of the work of what probate courts do. And just the other significant change, I'll note the most recent one is the Uniform Guardianship and Other Protected Proceedings Act, which became effective in 2019, which really changed adult guardianship in many ways, making them, in a sense, much more complex proceedings. So I will pause there before moving on to talk about some of the studies that have been done, the probate courts and their findings. So any questions that I can answer so far?
I'm just glancing around the screen and the room, and I'm not seeing any questions at this point. So I think
Okay.
we're good to go. Thank you.
Yep, absolutely. Okay, so as I mentioned, the next thing that I'll address are sort of the background of some of the studies, the studies that you have copies of. And I think the first context to be aware of with respect to those studies is what was happening in Maine state court. And I just mentioned a few significant dates to note. In 1852, the legislature enacted the Court Reorganization Act, which made a lot of changes to the original court, the Supreme Judicial Court, expanding the number of justices and expanding their jurisdiction. As I mentioned, the justices, because they were the court, they rode circuit, hearing both trials and appeals. So individual justices would hear trials as they traveled around to various counties. In 1929, the legislature created our statewide superior court system as the trial court of general jurisdiction to relieve the work of the Supreme Judicial Court. And in 1961, the legislature abolished, as I mentioned previously, municipal courts, police courts had been abolished before that. They abolished the trial justice system, and they created a statewide district court system. And with those two actions, with the creation of the superior court system and the district court system, all as part of the Maine judicial branch, Maine became one of the most unified court systems in the country, with all courts under this central statewide administration, with the exception of the county probate courts. In the 1990s, the legislature established several divisions within the state judicial branch, including most notably the family division, which was established in 1997 as a system of justice that is responsive to the needs of families and the support of children. And in 2001, the legislature enacted several other, I would say, unifying measures, including making the district court have exclusive jurisdiction over divorce and other family cases. You used to be able to get a divorce in superior court, so that was changed to really make the jurisdiction of the different courts or different divisions of the courts much more distinct within Maine. And I'll just say briefly that all of these changes that were happening in Maine were very consistent with national trends and with best practices. Starting at the beginning of the 20th century, in the progressive era, states began moving towards unification or consolidation of their courts, as opposed to the original English system, which was sometimes referred to as the for every problem there is a court, moving towards having more courts of general jurisdiction and unified courts with central administration. So they were consolidated in terms of their organization, they were centralized in terms of their administration. And then with that central administration, there was also empowerment, that there would be one court that would have the authority to issue rules that would govern all of the courts within that system, as opposed to having rules sort of all over the state in different systems. And the American Bar Association really supported this trend. And in 1913, the American Judicature Society was founded specifically to promote the reform of courts in terms of court structure and administration, and the efficient administration of justice was one of the objectives, and to really promote these changes happening around the country. The American Bar Association, actually 1974 rather, and then amended in 1990, they created standards for courts regarding court administration. And part of those standards, the best practices were unification. So Section 110 of those ABA standards stated that the general principle was that the aims of court administration can be most fully realized in a court system that is unified in its structured administration, staffed by competent judges, judicial officers, administrators, and other personnel, that has uniform rules and policy, clear lines of administrative authority, and a sufficient unified budget. So again, this was part of what was being promoted through the country. So all of these changes within the Maine judicial branch that were created by the legislature through statute consistent with these trends, none of these required constitutional amendments because they were all part of the general authority that the legislature had as part of Article 6. But the probate courts were left out of this. And they were left out because of this language that was in what's now Article 6 and Section 6 with respect to them being county-based, with respect to them being part-time, and being directly elected. And in doing so and leaving the probate courts outside of this unification, consolidation, these different reforms that Maine was undertaking, Maine increasingly became in the minority of what other states were doing with the courts that had probate jurisdiction. So today, most states do not have a distinct probate court. Probate jurisdiction, and again, you can look at probate jurisdiction in terms of various different kinds of cases. There's no one central notion of what probate jurisdiction is. It may include wills and estates. It may also include protective proceedings. It may include adoptions or some combination of these or some additional things or some fewer things. But in any event, most states today, and I'll talk more about this in a moment, the probate jurisdiction is in courts of general jurisdiction, meaning that they are in courts that handle matters other than simply these forms of probate jurisdiction. So the studies that, again, these two trends that were happening, the changes that the legislature was making to the state court system and leaving the probate courts out, that led to a series of studies beginning in 1952 that raised concerns and noted the challenges about the fact that probate courts were being left out of all of these reforms, were being left out of unification and consolidation. So I'm not going to go through in detail all of the reports. I'm going to, again, sort of weave them together as sort of the narrative that brings us to this commission and to the charge of this commission. So I'll briefly just note the dates and the names and the context of these commissions and their key recommendations. As you know, they've all been gathered and posted on the webpage for your commission. And also, Janet and Sam have created a really helpful summary of what each of those reports provides. I really encourage you to take a look at those reports. I mean, yes, they are from another time, but in some ways it's very interesting to look at them, to see the evolution, the development of thinking about this problem, which is, again, the probate courts being left out of these changes that were happening to the state court system. But you'll have the opportunity to take a look more at the methodology. Yes, so Senator Carney is holding up that summary. You can look at the methodology, who conducted the study, the data that was relied on, who was involved in developing their recommendations, and the reasoning behind them. And I'm not going to take the time to go through all of them in some detail today, but I do encourage you to take a look at them. And then I'll summarize the sort of, as I said, the key conclusions and concerns noted by one or more of them, sort of what we can take away from them as a group. The specific recommendations that you'll see, they change in many ways. Keep in mind that they reflected the state court structure at that particular time. So you'll see that they do change. But they also reflect the fact that there is more than one way to bring the probate courts into the state court system, which I think is really the question that's on the table for your commission. So I had already mentioned Professor Dow's 1952 study, County Government in Maine, which he conducted for the Legislative Research Committee. He was at the University of Maine. He was the chair of the History and Government Department there. And his conclusion, it was, again, a sweeping study about county government, but his conclusion at that time was that probate courts by that time should now be made part of the state court system, and that judges should be appointed in the same manner as district court judges, that there would be a need for fewer probate judges as a result of that, and the position should be made full-time with a commensurate salary, commensurate with other judges. I mentioned the 1964 changes to the Maine Constitution, and the context for that was, as I said, the report of the Maine Constitutional Commission although they had recommended that probate judges be appointed by the governor because of their work, as I quoted from them before, it was not included in the referendum because they wanted there to be more study of the question. And the Maine Intergovernmental Relations Commission made a report to the legislature in 1965, recommending the legislature undertake a study to determine the proper methods for creating a probate district court system. So probate district court system was the thinking at that time, and appointing judges. This received bipartisan support in 1966, and that led to a study that was done by the Bureau of Public Administration, the University of Maine, in May 1967. So that report was titled "A Report of the Preliminary Analysis of the Feasibility of a Probate District Court System for Maine." So note that they called it a preliminary analysis. It was actually a fairly thorough study in some ways, and it was done over a period of some months. The judges were interviewed, and there was an exploration of the workloads and the kind of work. There were many different aspects of the work of probate court that was part of that study, field interviews, data, and so forth. The report did not conclude with a particular proposal for what the court structure should be. It evaluated the pros and cons of full-time probate judges and the advantages and disadvantages, and it discussed the feasibility of creating a probate, a district court system for probate. But it didn't ultimately resolve the structure. It got hung up on the issue of salaries is one of the things that's reflected in there. So it didn't come up with a final blueprint for what was going to happen next. And so remember, 1967, this referendum had been approved by the legislature. Well, the legislature ultimately amended the resolve that went to the voters in the fall of 1967. Originally, that resolve had a February 1st, 1969 effective date, where that repeal was going to take effect of Article 1, Article 6, Section 6. And based on the result of this preliminary analysis, they said, we think there needs to be a more in-depth study, really need to look at what other states are doing, what the best structure is. Let's commission a more detailed study, but let's put this question of repeal before the voters now. So the committee amendments to that resolve removed the effective date of February 1 of 1969 and replaced it with the language that was ultimately enacted, which was, if it shall appear that a majority of the inhabitants voting on the question are in favor of the amendment, the governor shall forthwith make known the fact by his proclamation, and the amendment shall become effective at such time as the legislature by proper enactment shall establish a different probate court system with full-time judges. Out of the scores and scores of constitutional amendments, this is the only time that it has been, the effective date has been conditional. Every other amendment has had an effective date. And here we are 54 years later. My guess is that the legislature is probably not going to suggest this approach again. I'm sure that they did not expect it was going to take 54 years to have a commission coming up with the plan. They immediately commissioned the study that became the Institute of Justice Administration study. But I'll just note that at the time that the 1967 amendment happened, Senator Lund of Kennebec County, who was really the lead champion behind this, explained that we ran out of time to come up with a specific plan. We couldn't come up with a concrete recommendation as to which of several alternatives might be followed in improving our probate court. But they did note that we can't do anything, we can't make any changes until such time as the constitutional provisions regarding the probate courts are changed. So they wanted to go forward with just making those constitutional amendments and then figure out what the specific plan would be. So that's how we ended up with this very unusual amendment that's conditional. So as I mentioned, they immediately commissioned, the legislature commissioned the Institute of Justice Administration, which was located in New York, to do a study to sort of pick up where the prior, the Bureau of Public Administration had left off, which is examining this idea of a probate district court system. In their report, which you have, the IGA specifically considered and then ultimately rejected the idea of a probate district court system. They concluded it would not make sense to have 16 districts, county-based districts, because of the varying workloads. And then grouping it in other combinations would be inefficient. It would create travel burdens for the judges. They thought it would make more sense to merge the jurisdiction of the probate courts into the Superior Court and add a few Superior Court justices. And the IGA's report noted that 22 other states had somewhat recently merged their probate courts into courts of general jurisdiction, and that others had separate but coordinated courts within the state judicial system, and that the states that still had probate courts that were separate had not changed their probate courts in a very, very long time. So that was really more an old-fashioned approach. And so forth. And again, you can look at the report to see the reasoning for why they thought bringing the jurisdiction of probate courts into the Superior Court made the most sense. But they certainly concurred that there should be full-time judges, and they should be appointed rather than being elected, and that the work should really focus on judging rather than the administrative work that could be done by a register. So that was 1969. And the next significant development soon after that, and I think in the 60s, Maine had started wondering whether it should become a uniform probate code state, because we had not been until that point. So the legislature created the Maine Probate Law Revision Commission, so many commissions. They started their work in 1973, and they had two charges. One was, should Maine become a uniform probate code state? And they were also asked to consider this question of, in light of the changes that were coming from the Uniform Probate Code, what made sense for the structure of the courts that were going to hear Uniform Probate Code matters. And they issued their report. They did a series of reports, and I think you have a number of different items that came from the Probate Law Reform Commission in your materials, but they ultimately did have a final report. And their final report very much followed the logic, the reasoning of the IGA report from 1969. They thought that the jurisdiction of probate courts should be absorbed into the Superior Court. They evaluated several alternatives. Again, you can take a look at that, the pros and cons of those various alternatives. But they noted that there had been a particular concern over the appropriateness of part-time elected judges. They noted the ethical problem that is being raised by the existence of a part-time judge who maintains an active probate practice, and that had been brought to the attention of the commission by the Bar Association's Ethics Committee, and the appearance of a conflict of interest, and also the concerns about the anomaly of Maine's probate judges being the only judges in Maine that were elected. There was legislation that was created that would have implemented those recommendations. There was some concern in the legislature that perhaps further constitutional amendments would be needed before implementing those. And that led to the 1980 opinion of the justices of the Maine Supreme Judicial Court that you have in your materials. And they confirmed that legislation, that nothing in the Constitution prohibited the legislature from abolishing the probate courts. The references to the probate courts in other parts of the Constitution didn't mean that those had to continue to exist. And it said that the pending legislation was consistent with the language of the 1967 amendment, which was creating a new system of probate courts with full-time judges. And shortly after, but that legislation was ultimately not enacted. A few years later, coming at the question from a different angle, the Judicial Council commissioned a report to study court structure in relation to probate and family matters. And that's often referred to as the Cotter Commission. And they issued their report in 1984 to examine the operation of the probate courts. And in particular, they very much focused on this question of part-time judges and judges who were practicing law and the effect of the enactment of the probate code, which again was very new at that particular time. And also the implications for family matters, as they were noting increasing involvement of probate courts and overseeing matters involving children. So they issued a report, and they noted that the judicial work of the probate court has shifted away from traditional handling of probate estates and towards family matters such as guardianships and the like, and that was becoming an important part of their caseload. And that really suggested perhaps some changes needed to be made to the court structure. The Judicial Council, based on those on that report, made some recommendations. The initial recommendations were that the Code of Judicial Conduct needed to be applied fully and completely to probate judges. So there are some exceptions. Probate judges should be appointed, and the state should fund a probate court system. And they went through several alternatives. They didn't recommend a specific structure, but they came up with several alternatives consistent with those three key recommendations. Chief Justice McCusick, in his State of the Judiciary address, said that the Judicial Council ultimately concluded that there should be a phase out of the county-based courts, the way that the old, and I'm quoting from his State of the Judiciary on February 6, 1985, the old part-time municipal courts and trial justices were phased out by the legislature in the early 1960s. And the opinion there was that the estate and trust jurisdiction should go to Superior Court, but that the family law matter should go to the district court. So we see a bit of a shift in terms of how the new system might be set up. And that the registers should continue to be county-based to serve as repository of records. There was a commission in 1986 to study family matters in court, which noted the concern about having jurisdiction of family matters spread across many courts, Superior, District, and Probate. And then in 1992, the Commission to Study the Future of Maine's Courts included in its recommendations about the probate courts. And again, you have a few items from that study, which was very far-ranging and very in-depth. And the specific recommendations of the court's futures was that probate judges should be full-time. They should be part of the judicial branch. They should be paid the same as trial judges. They should be available for cross-assignment in district and superior courts. So there may be distinct probate judges, but there should be these cross-assignments. And they suggested that perhaps there are regions to be served by the various probate court judges. So again, we see a slightly different suggestion about a structure, but still within the judicial branch and still full-time appointed judges. And concern about preserving what was working well about the registries and the county-based orientation of the registries. And then more recently, the Family Division Task Force just noted the continuing concern about and the problems that were created by having certain aspects of family law handled in these courts that were not part of the state court system, and specifically the problem of simultaneous proceedings, that a child could be the subject of proceedings in both state and probate courts. So I won't mention all of the pieces of legislation that were proposed and that ultimately did not succeed as a result of each of these reports, but needless to say, the list is long. At various stages, they were not successful. In some cases, it was because the particular court structure that was proposed just did not seem workable, or there were concerns about the impact on perhaps the judicial branch about that. Certainly there was concerns about price tag, but there was always some concern that was raised that ultimately led to that legislation not being enacted. One change that did happen was in 2016, the 127th did enact the Home Court Act, which addressed some of the concerns raised by the Family Division Task Force with respect to simultaneous proceedings involving the same child. So ensuring that there would only be one court that would hear that. So just very briefly, what I'd summarize about what all these reports are saying, again, many different structures that are being proposed. So there's obviously more than one way to do that. And as I mentioned, often those different structures reflect what was different about the state courts themselves at that time, what the Superior Court was doing, what the District Court was doing. The creation of the Family Division obviously changed some thinking from going entirely toward the Superior Court to considering a role for District Court and having some jurisdiction. Many commented, they were not critical of the probate court's work. I mean, that's the first thing to emphasize. They were not saying that the probate courts were not staffed by dedicated, hardworking competent people. They, in fact, many of them emphasize the excellent level of service, particularly that was provided by the registers, the accessibility to having county-based registers to assist people with the administration of the estates. But none of these reports concluded, even though they lauded the work of the probate courts and their staff and their judges, no one concluded if it ain't broke, don't fix it, right? They all recommended that there needed to be significant reform. And specifically, all of them consistently said it should be brought into the state courts in some way, shape, or form. So this is really going back 60 years, all the way to 1952. Professor Dow was the first to suggest that they should be brought into the state court system. So the central concerns of all of these different reports really fall in two broad categories. One, there's no central system, right? Probate courts are not part of a central system, either a probate court system or, more importantly, the state court system. And the specific differences between probate courts, probate judges, and all other judges in Maine. So those are sort of the two big categories. With respect to the first category, the concern was that probate courts, as I mentioned, have been left out of all this modernization and restructuring that Maine had been doing, that the legislature had been doing to state courts throughout the 20th century, consistent with national trends and best practices, and that the legislature was just continuously limited in its ability to do that by the 1855 amendment. And it was particularly a concern once the probate courts were left out of the family division, with its dedicated rules, procedures, trained, centralized staff, all supporting the administration of justice for children and families. You know, there couldn't be family law magistrates involved with these cases, and so forth. You know, they were left out of the unified and simplified court structure with the central administration and support, again, part of this modern trend. You know, the assumption was when the Uniform Probate Code was enacted that probate courts were going to be part of the state court system. And, you know, concerns that the Supreme Judicial Court is overseeing appeals, administering rules, involved with judicial discipline, but the Supreme Judicial Court, this administrative office of the courts, were not part of the central administration oversight at the trial level of what the probate courts were doing. Concerns about fragmented jurisdiction, you know, being left out of the jurisdictional consolidation in addition to the administrative consolidation. The problem of controversies being heard in different court systems, not just in different courts. Probate law was just being treated differently from all other kinds of law. There were different rules of procedure in these state courts versus probate courts. There's a lack of uniformity of the procedural aspects of probate court work from one county to the next. As the 1967 report said, each of the 16 probate courts is in essence, a court unto itself, that there was no oversight or central rulemaking. They criticized, you know, the inefficient allocation of judicial resources because it was set by geography, county lines, as opposed to caseloads. So some judges were underutilized, while others were buried in busy dockets. So it was not considered efficient, and it created burdens. And then, as I said, the second broad category was concerns about probate judges and the office of probate judges. They were part-time with low salaries. And the feeling was that you really need to have full-time judges to increase the dignity and respect for the probate courts and their function. They should be paid what other judges are. But having a part-time servant who is really not on a higher level than the attorneys who are appearing before them, because they were still attorneys, did not, as one report said, did not comport with our traditional concepts of judicial process, you know, just bringing that dignity of the position. And the fact that probate judges needed to practice law to make a living. They had divided attention. They couldn't immerse in their judicial role. They required wholly different treatment under the judicial canons and the Code of Judicial Conduct, which made it very difficult for the discipline proceedings or bodies to apply them because they were both lawyers and judges. So which code do you apply when there's a discipline problem? And the most recent version of the Code of Judicial Conduct included this note in this introduction. This is from 2017. It said, this court has been adopted by the court after consideration of comments and suggestions from members of the bench bar and public issues concerning probate judges' part-time status, particularly their representation of clients in probate court matters, generated substantial negative comments. That issue, however, is a matter that can only be addressed by legislative action. So again, we see this limitation in the ability to make reforms. So these reports consistently raise concerns not about specific ethical problems or breaches, but the appearance of a conflict of interest, which one report said was ethically uncomfortable and undesirable, and particularly having judges appear before other probate judges or in other courts in the county in which they sit as judge, having other probate judges appear before them and sit in judgment of their fellow judges was awkward. Certainly awkwardness and discomfort for the attorneys and for the litigants when the opposing counsel is a judge. The need to transfer cases to another county when there's a conflict. And as I mentioned, the concern about elected judges when it's not true for other judges in Maine. And that created fundraising and election issues. And there's a whole part of the judicial canons that only apply to probate judges because they are running and fundraising and all of the issues that can come up with that. So that is a lengthy, but still brief summary of all of the reports up to the present time and the concerns that were raised by them regarding the probate court. So I'll pause again to see if there are any questions at this juncture.
Anybody have questions?
And I'll just emphasize it's not your last chance. If other things occur to you either at the end when I'm done or as you reflect on today, I plan to continue to be available to the commission and to your work if I can be of any use.
Thank you. So I am not seeing any questions right now. So yeah, you can continue if you'd like.
Yeah, I will. I'll just a few things I think for the commission to consider in light of all of this, some questions, and again, I was not able to hear your proceedings this morning, so some of this you may have already considered. But very much in a lot of ways, I think that the takeaway from all of these reports and their concerns is you can think of your objective perhaps in terms of preserving what's working well in the probate courts while addressing the concerns that led to the referendum in 1967 and the commission, this commission, as reflected in all of these studies. And obviously, the foremost question is what model should be considered for bringing the probate courts into the judicial branch. All of these studies considered various different models. So it's in some ways that creates a very challenging task. I mentioned earlier that most states do not have a separate probate court. So I think sort of one big question is there a distinct probate court or should Maine absorb the probate jurisdiction, the matters that probate courts hear now, into courts of general jurisdiction here in Maine? So I'll just mention a little bit about national trends. In 2014, which is the most recent sort of compilation that I could find of this, the National Council of Probate Judges indicated that 15 states still have designated separate probate courts of some kind to handle some of the matters that we associate with probate jurisdiction. But that doesn't necessarily mean that they are separate from the state systems. In fact, most of those are part of the same systems, but they are distinct probate courts. So that would include, for example, the Massachusetts Probate and Family Division within its state courts, or the probate division in the New Hampshire circuit courts. So they have distinct probate divisions, again, in Massachusetts, probate and family, but all the remaining states, so that would be 35 states, have probate jurisdiction in one or more of their courts of general jurisdiction. And again, sometimes the matters involving children go with one court of general jurisdiction, sometimes the estate and trust matters go with another. Name changes may be in either one, trust litigation may be in one place, administration of estates may be in another place. So a number of these surveys really do identify that. But interestingly, in 2003, that the survey indicated that, or rather 1993, 20 states had distinct probate courts. So the trend between 1993 and 2014 was that fewer states had distinct probate courts. More of them were pulling that probate jurisdiction into courts of general jurisdiction. So that's just national trends. Doesn't mean that that's what Maine should do, but that's sort of what the current changes have been from other states. I'm not aware of any state that has moved from pulling probate courts out of a court of general jurisdiction and making them distinct. So should there be a probate court in addition to superior and district courts? Should there be a probate division within one of those courts? Should the jurisdiction be absorbed into existing courts of general jurisdiction? Again, perhaps along the lines of some of the recommendations, some going to superior court, some going to district court, or perhaps keeping some that's a distinct probate court and some aspects of the jurisdiction being absorbed into a court of general jurisdiction. How many additional judges would be needed as a result of that? And that answer may be different depending upon that structure. What should the role of probate registers be? As you can see consistently in these reports, they really laud the work of probate registers, and their accessibility is important. Some of the reports really said that it's important that probate registers be distinct from being court clerks. They should be hired in the same way as court clerks, meaning they should be appointed, they should be hired within the judicial branch, they should be employees of the judicial branch and supervised, but that there was, many noted that their work is significantly distinct to keep them as distinct positions. So what should be done with probate registers? How should they be hired? How should they be supervised? What should be the allocation of work between judges and registers if registers are preserved? And certainly, considering the impact on the various populations, many different populations use our probate courts. There are people who are involved in highly contentious emotional litigation, and there are people there who need some guidance on administering their aunt's very modest estate. It's really a wide range of people. Quite a few unrepresented litigants are in the probate courts, but then there are also matters that involve, a lot of lawyers involved doing very complex, high stakes litigation. And obviously the questions that I'm sure have occurred to many of you, which is integrating the case management systems, the public facing systems, and of course the relationship between county and state government in terms of location and authority, and how it should be paid for. What should the impact be on county taxpayers and state taxpayers? I just want to briefly mention the materials that you've been provided, these charts. As I've mentioned, most states do not have a separate probate court, and I really want to applaud the work of Janet and Sam in pulling together those materials. I take no credit for them whatsoever. I did talk with them about what kind of information about what other states are doing might be of use to your work going forward. So I just want to explain sort of the thinking that was behind the charts that were created and how you may want to consider them. As I mentioned, most states have, there's a wide range of approaches to how probate jurisdiction is addressed by different states. What we thought would make sense was, first of all, to see what other New England states are doing, what our neighbors are doing, particularly Massachusetts, because Massachusetts, after all, was our original model for our probate courts, but they've moved away from that model. 1978, when they created their probate and family court as part of their unification. And that was after a study that was commissioned and was actually headed by Archibald Cox and recommended unification of the entire Massachusetts system. And that's what led to the creation of the probate and family court. Vermont brought its county-based probate courts into the Superior Court, and it created probate division within the Superior Court in 2010. In 2011, New Hampshire created a probate division within its circuit court. So those are included. And we thought it would make sense to take a look at what the other New England states are doing, because again, it really represents the diverse approaches. Connecticut has a statewide system of probate courts, but it is really adjacent to, from what I can tell, the other state court systems. It's really a distinct statewide, state government-based probate court system, but it's very distinct. And that has been in place for some time. Rhode Island has a town-based approach. They have, so their probate judges are part-time and they are appointed generally by town councils. They also have much more limited jurisdiction than our probate courts do, and they're much more charged with the administration of estates. And generally, when there's really contentious litigation, apparently those cases get appealed for a de novo hearing in Superior Court in Rhode Island, so they're very different. And we also thought it would probably make sense to take a look at what other uniform probate code states have done. So we included in the chart, the research, and again, Jan and Sam take 100% of the credit for the research, and what they came up with was looking at the states that had adopted the Uniform Probate Code at least as recently as Maine did. So we thought something that was at least capturing something from 1980 going forward. And it turned out that provided some good geographic diversity for us, as well as diversity of approaches. So none of them have distinct county-based separate courts, but they all take it somewhat different. North Dakota approaches probate court jurisdiction generally in their district courts. Hawaii has probate jurisdiction in circuit courts. South Carolina does have elected probate judges and distinct probate judges, but there are other judges in South Carolina that are elected, but those courts are part of the state judicial branch. In Minnesota, the district court has jurisdiction over probate matters, and in Washington, which is not a uniform probate code state, but it's the other state that's adopted the recent Uniform Guardianship Act. We thought that was worth looking at. It's part of their civil court system. So again, you can look at those charts for more details about how those are funded, the appointment of judges, whether there's sort of cross assignments, the scope of the jurisdiction that those courts hear, and other details. But I think it provides a really useful snapshot for you of the range of approaches for court structure. So I am going to leave it there. That covers what I have prepared to share with you this afternoon. I hope that it has been of some use to you and use for your work going forward. And again, I'm happy to be available to you as a resource if I can in any way, as well as for Jan and Sam. I've really enjoyed working with them. So I'm glad to answer any questions that you have.
Thank you so much. This has been very thorough and really interesting. Go ahead, Representative Cardone, with a question.
Yes, first of all, I wanted to thank you, Professor Smith, for your willingness to present today. And hopefully for your ongoing willingness to assist us in other ways as may come up as we move forward with our mission here. I have not had the opportunity to read closely this chart that our OPLA analysts put together. I intend to do that. But I wondered whether you had any observations as to, for states that have adopted the Uniform Probate Code and the Uniform Guardianship, Conservatorship, and other Protective Arrangements Acts, as Maine has. Are there any generalizations you can make or conclusions that you can draw as to, I guess what I want to ask is there any relationship between the adoption of those acts and the structure or arrangements of the probate courts?
I would say nothing that is distinct to the Uniform Probate Code that I can see. It's a little hard to say that because these states are all generally following the general trends that other states are doing. So it's hard to say whether, and I haven't delved into the history of what a lot of these states have done to see if they made changes specifically because of the Uniform Probate Code, if it reflects a decision, sort of like what Maine was planning to do in 1980, for example. But, you know, all of them have, the ones that were studied, at least for that, for purposes of this. And again, it's not every state that has the Uniform Probate Code, but the ones that have adopted the Uniform Probate Code from 1980 to the present, they're all part of the state court system. Most of them have it as part of their courts of general jurisdiction. But again, that's consistent with what other states are doing. South Carolina has distinct probate judges. It's in the minority, but again, that could be true. That is true generally for these 15 states that still have distinct probate court jurisdictions. So I think the brief answer is perhaps not, but it's possible that for some of these states, enactment of the adoption of the Uniform Probate Code provided perhaps part of the inspiration for the current structure that they have now.
Okay, so I'm just thinking about how this commission moves forward. It sounds like we don't need to keep in mind the structure or the provisions of the Uniform Probate Code when we are choosing from the various models. It sounds like they could all work with the statutory framework that we currently have in place. Am I correct in that?
Yeah, I think that's probably true. I think, you know, obviously, I think one thing that is perhaps, and I really defer to the judges and registers and those who appear before them on estate matters, this allocation of responsibility between registers and judges, that was a significant change from the enactment of the Uniform Probate Code. I think that seems to be reflected. I mean, for example, North Dakota has a sort of a formal versus informal probate code distinction proceeding, much like we do. And I think that's a reflection of the Uniform Probate Code. But they've structured their courts and the way those proceedings are heard a little bit differently. So again, they note that distinction, as do we, but it's led them, I think, to something that's perhaps a little different from what we have set up. So yeah, I don't think there's a direct line from one to the other.
Okay, thank you.
I think there's flexibility. I think they're adapted. And I think that was part of what the 1980 Commission ultimately held. They said that the probate code does not require a particular structure, but they considered and they looked at all these different models. And they said ultimately absorbing, again, at the time in 1980, absorbing the jurisdiction of the Superior Court still made the most sense to them, just as it had in 1969.
Members of the commission, are there other some questions and comments for Professor Smith? Okay, go ahead.
First off, thank you, Professor Smith, for your scholarly work as always. As I delve through this, there's obviously so many options we can go with in terms of trying to get to the answer of full-time judges and registers and relationships between those. And I look at these options and I'm wondering, is there any state that has an appointed state judge paid for by the state and an elected county register paid for by a county where the appointed judge can oversee the resources of the county? Is there any scenario like that?
Offhand, and again, I can look at that and let you know, there isn't. Massachusetts in 1978, they created sort of an interesting hybrid, not exactly what you're describing. So in Massachusetts, they have continued to retain their registers as elected and elected by the residents of the county. But my understanding is that those registers are paid for by the state. And I reached out to some folks in Massachusetts who are involved with court administration. They indicated that there are perhaps some challenges with that particular structure, with having elected county-based registers who are working with judges in this sort of more general jurisdiction, the probate and family division. But my understanding is that they are, and I think this was part of what Janet and Sam turned up, that the registers are being paid from state funds.
In your opinion, is that system better than our current system and your findings? And I know I'm putting you on the spot, but
No.
you're so clever, I just have to.
Well, you mean in terms of, the Massachusetts system as a whole, I think is worth looking at. I think looking at the probate and family division as a whole, in terms of their system of having elected registers paid for by the state and supervised by judges who are appointed, there was nothing that I came across in my research on that a few years ago that suggested that was an ideal situation. But I think the probate and family division, from speaking with some individuals both within and outside of the courts in Massachusetts, That seems to work well. Having that broad jurisdiction, and again, it's somewhat specialized, but it's broader than the current probate courts. And then there's some overlapping jurisdiction in the probate and family division, such as with their juvenile court. And that seems to work well. What I heard was that they find that the judges there have the flexibility they need to hear the matters in the appropriate court with the, that may, particularly for matters involving children, if they're involved with a related proceeding. So they seem to think it works well. So I think the Massachusetts model is probably one taking a good look at.
Yeah, I'd like to ask just a follow-up question, because I think you had mentioned, Professor Smith, that there were some challenges with the elected registers and the appointed judges. Did you hear any, or do you have any specifics with what those challenges are that you could let us know about?
I'm just looking back at from my notes, the limitation, they said the limitation was there was an ambiguity about the degree to which the central administration of the courts could provide oversight of the registers. That was what I heard. That was the specific challenge, because they were elected by county voters, and they were not being treated like all other clerks. There may be some other clerks that are elected in Massachusetts. I'll have to go back and look at that. But most clerks in Massachusetts are judicial branch employees that are hired by the judicial branch. So the fact that their path to their office was different apparently led to the perception that they were more independent, or perhaps the reality that they were more independent of the central administration of the Massachusetts court system, and that's what led to some difficulties. So that was the specific, that was specifically what I heard.
Thank you. Other questions? I do have one if nobody else has a question. It looks like in this chart, some states have distinct probate judges and others don't. And we've heard about kind of the special expertise that may be required by probate judges, and that is a basis for maintaining a distinct group of judges. Can you share any thoughts you have about whether that kind of unique expertise really is a reason to have a separate group of judges working on probate matters, or whether over time you could see a transition happening where judges could handle those among all of the other complex matters that judges handle?
Yeah, I think it's a really important question, and it's one I've thought about. I'm not sure I have a definitive answer about it, but I guess I would think about it this way. Again, we need to remember that there is no necessarily, uniform assumption about what probate court matters are, right? So we have what our judges are doing right now, which again, I sort of put in 3 broad categories, and it's not exclusive. I am always amazed. I'm constantly coming across like, oh my goodness, probate courts do this too, and they do that too. But, we think about estates and wills, estate administration, sort of traditionally, I think what most people on the street would associate a probate court would do. There is protected proceedings, adult and minor guardianships, conservatorships, and adoptions. And I'm just thinking in terms of volume of courts, volumes of what they do. And of course, there's name changes and so forth. Some of those matters may align very well with the expertise that state court judges are already doing. Obviously we already have state court judges who are doing minor guardianship and adoption cases as a result of the Home Court Act. They didn't do them before. They learned how to do them, and now they're doing them. And they're also doing name changes. So there are certainly several aspects that are already being heard in state courts. For protective proceedings, there certainly are plenty of examples of issues of, with adult protective proceedings, I would say, putting aside minor guardianship. Judges are hearing matters of competency, of mental health, and so forth. So many of those issues are already part of the jurisdiction of our existing state court judges and so forth. And some superior court judges certainly are hearing estate-related litigation. So some of that does come up and is part of the docket. So I would not say it's a wholly alien world to what our state court judges are already doing. But I think that some of the aspects of the estate administration, may be very distinct. It may make sense to have real expertise within the judicial branch, people who are very much focusing on that kind of work. Of course, that expertise exists not only in the probate judges, but in our registers. And I think, that may be one of the reasons why you're seeing so many states continuing to have probate-focused registers, as opposed to having just any court clerk doing what our probate registers do now. So much of that estate administration work is really being done by registers. So it certainly is possible for that expertise to be absorbed into courts of general jurisdiction, as we see. That's what most states do. Most states have taken that approach. But I think there can be certainly some value of having assignments, and that's very much how the Massachusetts approach is. I mean, they have courts tend to be focused in terms of their assignments. They're within the probate and family division, so that they. I sometimes I do worry that our judges in Maine, our superior and district court judges, we ask so many different things of them, and I know that a lot of times the way that assignments have worked within the judicial branch has, there are some judges who very regularly hear juvenile proceedings, who very regularly hear child protection proceedings. FEDs, for example. So I think there is some recognition that having judges' expertise or their work not spread so far to allow them to really hone in on that expertise is something of value. So I think that's absolutely worth keeping in mind when you consider the potential models of bringing the probate jurisdiction, perhaps within courts of general jurisdiction, how that will work to preserve that very specialized knowledge that our probate judges have now.
Thank you. Commission members, are there other questions for Professor Smith? I'm not seeing any hands up. I just wanted to invite the judges and any member of the commission actually who is here who wants to comment on that expertise issue, because I do think that it's a really interesting issue for us to think about as a group. Go ahead, Justice Gorman.
So I agree completely with what Professor Smith said. Although our judges currently do not do a lot of trust and estates, as was alluded to earlier by Judge Avantagio, there is shared jurisdiction over some estate issues. And so they're not hearing exactly the same case that a probate judge would hear, but they are hearing aspects of it. And you'll recall that judges are chosen by the governor. Should probate law be included in the jurisdiction of either the district court or the superior court, that would be one more area that the applicant for a judicial selection would be asked about. Do you have any expertise in this area going forward? So I'm not the least bit concerned that our judges can't do it. It's just that they're just not doing it now in the same way that probate judges are doing it. And the district, with regard to the family cases, I think Judge Mitchell would agree with me. There's not a whole lot of real estate between what a probate judge does in family cases and what a district court judge does in family cases. They're seeing the same families, which is one of the reasons for the Home Court Act, and they're doing the same things with those families. It just is, it's a pretty much a shared jurisdiction right now.
Thank you. Go ahead, Representative Cardone.
In the last legislature, the 129th, when I was part of a probate, a judiciary committee subcommittee looking at the issue of integration of the probate courts and dealing with elective judges, we reached pretty much the same conclusion that Justice Gorman is talking about now, in that right now with judicial selection, there isn't a great deal of emphasis on probate matters because there isn't a need to be. But if the probate jurisdiction was integrated in the district and superior courts, it may be that the appointments immediately following, that the governor is going to have to be cognizant of the need to beef up the bench with people who are more experienced in probate, whether they had been county probate judges or probate practitioners. But over time, that the whole expertise would integrate as the court system integrated. So it didn't strike us as a long-term perplexing problem, but something that the governor and the Judicial Selection Committee would just have to be aware of as they started filling these new appointments.
Yes, go ahead.
Professor Smith, I was wondering if you could comment on the Uniform Guardianship Act and the tracking of guardianships and of people under guardianships. Because there's only 2 states in the nation right now that have this, the difference between Washington state and the state of Maine is the state of Maine does not have a guardianship division within their state tracking and taking care of people under guardianship. Washington does, and they also have a division to help guardians be trained. We are doing the tracking of the people under guardianship, and it is a big job. And I wonder what you think about those cases going to the state. And there are judges that know about competency there, but to me, there's a big, wide difference there.
Yeah, thanks for that question. Although Maine and Washington are the only states that have adopted the newest version of the Uniform Guardianship Act, there are many states that have prior versions of the Uniform Guardianship Act, or have, I think every state has some kind of protective proceeding. And I think every state faces the exact same challenge, which is tracking and monitoring and ensuring the supervision of people who have been given this fiduciary power, which is a very important fiduciary power. I think that's wonderful to hear that Washington has a whole system in place for training and monitoring guardians and people who are in that particular role. I don't think that that is something that necessarily is associated with the 2017 Uniform Act. I think that probably, you know, as I said, every state has some kind of protective proceeding law, and they all face, I think, that same challenge, which is the monitoring and ensuring that that people are being people who are under guardianship are being adequately protected. So I think that certainly part of what would need to be considered is the role of state courts in providing that kind of monitoring. Most states in the country have courts of general jurisdiction or probate courts that are part of the state court system who are overseeing guardianships and conservatorships and ensuring that people are not being exploited who are in that situation. So I think Maine can certainly look at what some of those other states are doing.
Judge Crockett?
Thank you, Madam Chair. It was pointed out aptly that there is a great deal of overlap and redundancy on the minor guardianship cases between the probate courts and the district court. However, the distinction and the reason though that overlap exists also needs to be pointed out to the commission. I have a great example. Recently, I received a minor guardianship case that's in great dispute from an abutting county. And shortly thereafter, I had to require that the biological mother's estate also be transferred to my county, because the funds from the wrongful death in the mother's case need to be dealt with and administered in such a way to benefit the minor children. That's not a function right now that the district court has, nor does the superior court for that matter. So you'd have to have substantial changes to Title IV. But I think it's not insurmountable. It's training, and by any of these judges are more than qualified. Maine's blessed with great judges right from the top down. But the point is that there is a distinction in the law, and we can't disregard it, because that's the very purpose of having a court of widows and orphans, was because of the administration of the assets for the benefit of the minor children. So just bear that in mind as we go forward.
Thank you. Go ahead, Judge Mitchell.
Thank you very much. It's very helpful to me to have charts, and I'm sure it is to everyone else. And I know how much you've worked on it. You also presented to the judges of probate as we're all trying to learn. Of all the discussions that I've been privileged to hear recently, there seems to be a lot of concern, or what shall I say, interest in maybe dealing with the family division because of the overlapping things. And I'm just curious, what would be the, let's say that we did absorb all the family, at least the minors, into the family court, what would the role of the magistrates be? I've always been concerned a little bit about the judges and what they're able to do and the limitations on magistrate, as well as looking at us who are judges. I mean, magistrates are appointed, we are elected, and the state court judges are appointed by the governor, but you have all these levels of abilities to act by statute. And I was just curious, in this world of a single family court, it would have to be rethought on the district court level as well as our level. I'm just curious about how all these parts fit together.
Magistrates don't preside over all matters that are heard in the family division. That's a legislative, that's a policy decision. They certainly have a role. The role is sort of most pronounced in the area of child support. And that was really much of, and certainly a significant part of the funding for magistrates comes from child support enforcement, and that's where their authority is the greatest with respect to that. And that's obviously, providing support for children is a critical part of what the family division does. But the other end of the spectrum, there are aspects of family law that magistrates do not have any role. And again, that's very much dictated by the statute. So they're not involved in child protection proceedings. They cannot terminate somebody's parental rights, including under the new law that was just enacted, clarifying when one parent can seek to terminate the parental rights of another. Magistrates do not oversee those proceedings. They don't oversee contempt of court proceedings. They don't oversee juvenile proceedings and final contested divorces that are lengthy and so forth. So I think that it certainly can, the case management function and the ability to get a family in quickly when there's an initial proceeding, to get it on its way towards mediation, perhaps the appointment of a guardian ad litem, dealing with a Clifford order. I think there are many ways that magistrates can be useful in a range of proceedings. But I think ultimately the degree of their authority, I think that's a question probably the legislature would benefit from some suggestions from this commission.
Yes, Representative Cardone.
Just as a follow-up to that, to Judge Mitchell's question, and Justice Gorman, you may be able to answer this or to help me with this. I know that initially magistrates were paid at least in part by federal funding that was provided under the assumption of child support services or child support collection services, 4D services, I think they called it. And with that federal funding came certain restrictions on what magistrates could or could not do. And then the legislature and the judicial system fashioned their role around those restrictions. And do those restrictions still exist? Am I correct that that funding and those restrictions from the federal government still exist?
Yes, you have it exactly right. Currently, I believe it's 3/4 of the magistrate's salary is paid directly by 4D reimbursement, and the remaining amount comes from general fund monies. And in order to continue to access that stream of funding, the magistrates' jobs have to be restricted, because if they step outside of their roles, we can be tagged by the federal government and not receive the 4D funding, which is reimbursement for collection of child support. So Judge Mitchell, as both Representative Cardone and Professor Smith have indicated, the role of the magistrate is it's a hybrid. It's an attempt to get people into court early enough so that child support can be put in place. That was the original rationale behind it. And a recognition that in order to determine what the child support is, you have to figure out an initial parental rights order. And then that case management function has continued on, but there are some significant restrictions on what they are permitted to do.
Yes, Judge Crockett.
So that begs an excellent follow-up, and I'm curious because I just don't know the answer. On our guardianship cases in probate court, I also do child support orders. Now, oftentimes the state is excellent about assisting. In a guardianship in district court, does the magistrate handle that portion of a hearing for child support for the minor guardianships?
So Judge Martin is in a much better position than I to answer this, but I do not believe that magistrates are currently handling guardianships. But John, you're in a better position than I am.
Yeah, no, that's correct. I don't see, and as I said, I mean, there's a difference between the guardianships the probate court handles as opposed to what the district court handles. By the time we get something like that, we're dealing with the actual child support, not the magistrate. So it's not really their, it's not in their, it's not case managed that way, I guess is what the easiest way to put it.
That makes sense.
Opening up the floor for other comments and questions. Anybody wish to speak? Go ahead.
Professor Smith, I know this is probably, I don't know if we're allowed to ask this even. This is my first time on a commission, so forgive me if I shouldn't ask this question, but I've reviewed the law review article that we were provided that you drafted. And it was back in 2016. I know there's some changes have been made, obviously, or some changes have occurred since then. You've done a ton of research on this, obviously, and you know the main court system well. Do you have any particular recommendations you can make at this point to this commission, or is that something that we should draw from what you've given us?
I wish I could shorten your work for you. I think that you know, that article and the research that I did, I think is relevant to your work, but I think there's a lot more information that you need to gather. So the short version is no, I don't have a recommendation for a very specific structure, because I think there is more information gathering that's needed for that. So I would not. I do not have a conclusion at this particular point of something that is specific. I mean, I certainly take from all of those reports the importance of being part of a system, being part of a state court system, having full-time judges. You know, all of those things seem to be essential, but it also seems that that's really part of what was being addressed in 1967. And that is what the reports since then have been very consistent about. In terms of the best way to first of all, oversee the transition and ultimately where that transition lands, I think that there's more discussion to have. So I would defer having a specific opinion about what the structure should be at this time. I wish I had the answer to that, though. I think that's what's important about the work that you all are going to be doing, and the challenge of it at the same time.
Okay, Judge Mitchell and then Judge Crockett.
Professor Smith, you hit a question where I'm sure our chairs are going to take us after everybody stops talking. You need more information to hone in on a specific direction. Can you guide us at least into what information would be most helpful to us as a commission when we're evaluating these various models? What's missing in your information model?
Well, I think, you know, foremost is getting a very good grasp on the work of the probate courts, you know, and I think in terms of, it sounds like you had an excellent overview this morning, and I know that that you, Judge Mitchell and Kathy Ayers and Judge Avantaggio all helped everyone understand the kind of work that's being done. But I think, and one of the things that was picked up in some of these other reports, you know, is the volume of that. You know, how many, since we were talking about the estate work versus the family law work, just to use that as an example. When it comes to the judges themselves, because it seems that sort of answering this question about what should happen with the judges, how much of the judge's day is actually being spent on estate matters, and how much is being spent on litigation that concerns children, for example. I think having a better grasp on how court time is being spent, I think is going to be very important. And as I mentioned to the probate judges when I was talking with you last weekend, cases only, the number of cases don't give a full picture. I think what's important to understand is judge time. Is how judges are actually spending their time. So, does a minor guardianship or an adult guardianship case, what does that translate to in terms of judicial hours? Judicial hours in terms of proceedings, in terms of writing, in terms of other aspects of that. So I think having a clearer picture of what the work is, the allocation of work between judges and registers, I think is another important part to get a good understanding of that. And obviously what kind of other court resources are involved with the administration of justice over these kinds of cases. So I think that kind of information, and I know that in the past, for example, when the legislature was considering the Home Court Act, the data that Kathy Ayers compiled from all of the probate registers around the state was critical to answer that question, which was, what was the impact going to be on the judicial branch for absorbing this category of minor guardianships? That could not have been done without the data that she and the other registers provided. So I think that's just a few examples of what is potentially missing.
Thank you very much. And Judge Crock, go ahead.
Thank you, Madam Chair. To sort of dovetail and expand on what Judge Martin said, I guess I have to know what your thoughts are. And this is a provocative question, so forgive me. What's the greater evil, elected judges or full-time judges? Or part-time judges, I'm sorry. I guess I'm looking, if we had to prioritize which one we fix, and we can only fix one, which one is it?
For what it's worth, my opinion is my opinion. I think that's an easy answer, which is part-time judges are the bigger problem than elected judges. I think that that is more of what, and I'm taking from what the other studies have found. Lots of states have elected judges, and they have the problems of elected judges, I won't go into, but, certainly they've been documented, that you inject politics into anything. Some people may raise concerns about the extent to which we have a merit-based system as opposed to a politically based system. But the part-time judges, there are multiple problems that the studies all pointed to from having part-time judges. One is the fact that they are part-time. Just simply the fact that they're part-time, that they're not, immersing their careers into judicial work, and the availability that's involved with that, and the dignity that's involved with that. There's just it certainly raises the respect that is given to someone who is in that role as their full profession, as a public servant. So there's those limitations. But the other significant limitation about part-time judges that these studies point to consistently, going back to the early 60s, is the fact that they must practice law at the same time. That they're underpaid, and that they need to make a living. And so that creates all sorts of needs for special rules, and it creates all sorts of discomfort among judges, with the judge themselves, with the limitations on what can be heard in their court, transferring cases, and particularly, problems with respect to the attorneys and litigants who are appearing before them or are appearing with them as being an opposing party on the other side. So there's certainly challenges involved with both of them. I would add that, Maine, there are some other states that have part-time judges. I think few of them have part-time judges that have jurisdiction as important as probate judges do. You know, they have some of these sort of lower level types of judges who perhaps don't have as broad jurisdiction. And those folks have very strict limitations on the kind of law that they can practice, where they can practice. And so, you know, they really need to, you know, they're really sort of trying to protect all of the downsides and potential appearances of impropriety that can come up. You know, they can't practice in their county at all. They can't practice the kind of law that's involved with the court over which they are a part-time judge. But, you know, again, they tend to have very limited jurisdiction. And in some of those cases, those part-time judges aren't even required to be lawyers.
Go ahead, Representative Cardone, and then we'll come back to you.
To follow up to what Judge Crockett is saying, I believe also, if I'm reading the constitutional amendment and the opinion of the justices correctly from 1980, I think, we meaning the legislature, in order for that constitutional amendment to take effect, the legislature must create a system with full-time judges. It doesn't say they can't be elected, but they must be full-time. So I think we have to go with the full-time and figure out how to get there, or we haven't fulfilled the conditions upon which the constitutional amendment would kick in and allow us to modify this system. Am I correct in that interpretation, Professor Smith?
Yeah, I think that is, you know, I'm not sure that any of these commissions, I mean, I would say going back to 1952, everyone who has made a recommendation about what should happen with the probate judges made two recommendations at the same time: that they be appointed by the governor, just like every other judge, and that they be full-time. I think the amendment is written the way that it is because of the way that the 1855 amendment was structured and what the repeal is. But you're correct that the language, you know, if you repeal that language, what you are left with is Article 5, which says that governor appoints judges. So I think that's part of it. You know, if you take out the language that says that they shall be elected by the residents of the county, then what you are left with, because what it says, what Article 5 says, is the governor shall appoint all judges except for, you know, probate judges and other judges, if that is provided elsewhere in the law and elsewhere in the Constitution. If you take out that elsewhere language that's in Article 6, Section 6, then what you were left with is judicial appointments. Now, this is not to say that there couldn't be a separate statute that was created that would allow for the election of just this kind of judge. I think the legislature may have the authority to do that because of the way that language is written in Article 5. But I would just say, again, going back to 1952, the recommendations have always been consistent. Probate judges should be appointed because it's important to be consistent with the way that other state judges are. And I think, you know, not to have them as an anomaly, not to have probate courts and not to have probate law treated differently from other areas of law. There is no rationale that anyone could find to treat probate law so differently from all these other important aspects of law, because it is a very important aspect of the law.
Judge Crockett?
Yes, and I recognize that what the amendment says, but the reality is it is its own separate body of law. I mean, there's a National College of Probate Judges. Nationally, it's always accepted as a even within those states that don't have a standalone probate court, they have a standalone probate division, because it is a strange and archaic body of law that goes back to widows and orphans. So it's always going to be a little bit different, even if we roll the entire system into the judicial branch. I don't envision the judicial branch separating it out to, and I think we've already discussed that there will have to be special judges with special expertise in that matter. just like we have a drug court or a veterans court, or we have family law judges and so forth. So that'll always exist. But I guess the reason I was asking the question to begin with was the differentiation between full-time and part-time judges. Have you done any sort of research with the various probate courts to determine, because we have judges that sit full-time essentially, and all of us are on call all the time. And some of us, it's a little bit different. So how, in your research, were you able to get any answers in terms of what hours existed? Because I mean, you're in Cumberland and that judge sits 4 days a week, and York is pretty close to that anyway, despite the fact they're not exempt from the CLE requirement. But what is, do you have any research on that particular issue?
I think that what I took from what a lot of the reports were talking about, one of the additional difficulties of having county-based, again, part of the reason why probate judges are part-time is because they're county-based. And some counties have caseloads that really demand having probate judges at the court at least 4 days a week. Other ones do not. And what these reports have criticized is that that's not a rational allocation of judicial resources when you have it restricted by geography in that way. And what they've concluded is that it would be much more efficient to take a look at what the work is that all of these 16 judges are doing, and how many full-time judges would it take to do that, to the extent that and that's one of the reasons why the county-based system and the full-time tend to go hand in hand, because having a full-time judge in some of the counties that have caseloads such that the judge only needs to perhaps, I mean, yes, they're absolutely on call. They're on call for PPOs and emergency guardianships and other types of proceedings. But in terms of being present and really devoting all of their professional energies to that, not every county has that. So the criticism has been simply delineating that based on the size of the county and the geographic lines of the county as opposed to the workload did not seem to be a rational allocation of judicial resources.
Pardon me?
I guess that begs the question, rational allocation of judicial resources. All these resources are paid for by the county, right? As opposed to the state. So I guess I'm wondering how you define that term, because the asset and the resource itself isn't paid for by the judicial branch. So it's a great deal for the judicial branch. I mean, you get thousands of cases a year adjudicated and paid for at the expense of the county. So I guess I always wondered about that logic. Is it just the judges are so valuable that they should be spread out more? Or, I mean, it's a county budget as opposed to a state budget. So, and I'm not in the.
I would say that I think the reasoning, just to respond to that, I think the reasoning is that they were not seeing, these reports were looking at the impact on the people of Maine and all of the taxpayers of Maine, and where it makes most sense to share the expertise of the people who do this kind of work. So I don't think they were focusing on county isolation. I think they were looking at the impact on the state of Maine.
Yeah, that's how I took it too. It was more from the statewide perspective than from the bucket out of which the pay was coming for the judges. Other questions or comments on this topic and on Professor Smith's wonderful presentation? Scanned everyone, and I don't see any hands raised. So at this point, Professor Smith, did you have any final information or thoughts you'd like to share with us?
I don't think I do at this time, other than to thank you again for the opportunity to talk with you about some of my research and to wish you good luck. Again, with what's clearly a challenging task. I mean, you're already asking great questions, and I think that's very encouraging. And just continue my offer of assistance if I can be useful in any way.
Thank you very much. We are grateful for your offer and we'll definitely take you up on it. You're welcome to continue to participate today. If you'd like, we're having a panel that will start in about 10 minutes, and I think we'll do kind of a 7th inning stretch for everybody before we resume at 3:30. So uh, you're okay, everybody. So we'll be back at 3:30. And again, if you're logged in via Zoom, please turn off your audio and video during the break. Thanks, everyone. Turn this on.
Yep.
Hello, everybody. Welcome back from our seventh inning stretch today. The next part of our program is going to be what we've called the practitioner panel, professional perspectives on probate court structure. And we had scheduled 3 guests. Attorney Perkins has been called away on a professional emergency. And so we have available here today Judge Richard Morton, who is a retired probate court judge. And then we also, I believe, will be having via an electronic sign-in attorney Patricia Nelson Reed up, and just like magic, here she is appearing on the screen. And so I think what we'll do to start with is that we will have Richard Morton and Patty Nelson Reed introduce themselves, and then we'll begin the panel. And welcome very much, welcome both of you to the commission to study a plan, to come up, to create a plan to incorporate the probate courts into the judicial branch. And Richard, we'll begin with your introduction if you'd like.
Thank you. And thank you for inviting me. I am Richard Morton. I live in Farmington, and I am a retired probate judge, so I greatly appreciate the request to come and visit with you today. I do have a couple of other items on my area of experience that are apropos, so I'll just mention them. I was probate judge for 36 years in Franklin County. I defended, represented parents and children in child protective cases for over 40 years. I was also an Army judge advocate with the Maine National Guard and was state staff judge advocate and served in those positions for 23 years. And I was an assistant district attorney under both Tom Delahanty and Janet Mills early in my career. And finally, I worked as the legal aid to the Republican leader in the Maine House in 1978, 1979, when I first came back off active duty. And in fact, that was when the probate code was being considered by the legislature. One of my duties was to attend all of the traveling road shows that Professor Loper put on around the state, and then to brief the Republican caucus on what the probate code meant, how it was going to work, and then attend all the Judiciary Committee hearings. So I was kind of in on the ground floor of the probate code process. So thank you very much.
Thank you for that wonderful introduction. And now we'd like to welcome and introduce Patricia Nelson Reed. And you can just go ahead and introduce yourself.
Sure. My name is Patty Nelson Reed. Good afternoon. I'm a practicing attorney. I haven't not anywhere near as distinguished as a experience as Dick Morton has. He's great fellow and has been a great contribution to Maine. I've practiced in the probate courts for about 28 years now, primarily in southern Maine, but also throughout almost all counties. We've either filed documents or have appeared before the courts over the years. I was asked to prepare like a 10-minute comments. So I have done that. Hope that's okay. Otherwise, I'm happy to not do them. But if you'd like them, I did them last night till about midnight last night after thinking about it a lot. So probate courts have a unique jurisdiction and type of practice that is accessible to the public, often routine and often not contested. And therefore, it's unlike other courts in our states. It would be unfortunate to lose those unique benefits to the practice. Judges that are more accustomed to traditional litigation, the American legal system is oftentimes based upon adversary. You hear from both parties, and the truth is found with that. And that approach in the probate court it doesn't work that well. It's not as open as an informal as the probate courts as they exist today. NPR had a recent podcast just in last week, October 12th, and it talked about half of the people in our country die without a will. And in this little NPR podcast, it was saying that the probate court was one of the most, if not the most important court, because most individuals will not get to a criminal court or a civil court. If they get divorced, they will, but if they don't, there's no court process in their entire life. Yet everyone knows someone who dies. They have a family member who dies or someone who dies. So most people indirectly or directly end up in probate court. And it was talking about what an important system and process a probate court was. Probate courts may have to address disputes, but a vast majority of the matters before them do not involve disputes. Yet they do involve some of the most sensitive fundamental events of a person's life. And although probate courts address a number of issues like name changes and adoptions, I'm just going to speak about the three primary practices that I've addressed, and I think the primary practices of the probate court. And the first practice is the decedent administration, the death of a person, and the filing of a will or a filing of an intestate estate. There's huge loss, confusion, crisis, grief among oftentimes the petitioner and the family members. And there can be, again, I'm sure all of you are from amazing families with no dysfunction, but in our world around us, the dysfunction that might be with families sometimes comes more alive when the matriarch or patriarch is gone, and there's grief and there's confusion. But yet the probate system accommodates this, but doesn't invite disputes as it exists now. They may be there and you may have to work with them, but the perspective is not one of dispute, it's one of accommodation. The probate courts for decedents assist with the process of the estate administration. The vast majority of cases, there'll be an informal process where the judge probably will never see it. It's through the Register of Probate. Documents are filed and a personal representative is appointed. An abstract is filed if there's real estate in the Registry of Deeds. The probate court publishes notice, publishes notice in a newspaper for creditors, sends notices to heirs and devisees. And then the personal representative manages the estate in a private process. The audience are the takers under the will. The audience can be heirs, possible creditors, there's taxing authorities for tax returns, but it is a private matter. And when the process is done, the personal representative submits, again, the second time to the court process, submits a document saying they've done their job and they attest to that. But this whole process starts with the probate court and ends with the probate court, but the rest is a private matter. But if there are disputes, if there's disputes among the beneficiaries, if the beneficiaries feel that the personal representative isn't doing a job, that court process is there to address the disputes. And if it's litigation, to address it by litigation. The other process in probate courts for administration of when people die is a more formal probate process. And that occurs if there is handwriting on a will. There's a confusion which will controls. Which happens a lot in Maine, where no estate is not administered for more than 3 years. There's a will, but nobody realized that, we have to deal with the will. We have to deal with real estate. In those situations, you have to go through a more formal process. There will at least be one hearing. And if there is a dispute as to who serves, There is a formal process and there's a disputing, a litigation type of process, but even most of the formal process is a problem-solving process, but not an invitation for litigation. So we just don't see as much litigation as you might in other areas. But if there is a dispute, the court has all the formality and all of the processes that are indicated for that. The second primary practice in probate courts is guardianships and conservatorships. A guardianship is where an individual's rights are either limited or taken away for making personal decisions. And a conservatorship is where an individual's rights, either in part or in full, are taken away regarding financial decisions. These are fundamental rights, due process. They come also at difficult times in persons' lives. Parents might have an 18-year-old who's been significantly impaired from birth, and you're legally becoming an adult, but they need to be involved and they need to limit some of those rights. That's one of the pressing points. It may be mental illness with a loved one, and the mental illness is out of control and the person needs protection from himself or herself. Or it may be, again, our seniors, where a parent or a grandparent or an aunt or uncle or a loved one or a spouse is becoming diminished and is unaware of it and is unsafe. So crisis, again, fundamental points in a person's life, and they've got to go to court. Now, most guardianships where the person's rights are taken away and there's usually not money involved, most of them, people are pro se. People are going to the court. They're getting forms. They're asking the court questions. They're appearing without an attorney. Conservatorships, some are pro se, but a lot are represented by attorneys. But the probate court's goal is to be the gatekeeper, to be the beacon of due process, to make sure that the person's rights are only limited if necessary, absolutely necessary, and they're limited in the manner that they should be. But their goal is to protect due process, but also these are very fragile situations. So they don't want to unnecessarily trigger adversarial proceedings because these are family matters. We're talking about people's court and family court. So that personal lack of formal legal obstacles are very important. Another unique aspect of the probate court is that this guardianship or conservatorship relationship may last for 10, 20, 30, 40 years. Someone may be 19 and under guardianship and may live to be 89, could be 70 years. And during that entire process, while someone's under a guardianship or conservatorship, there are annual reports now that have to be filed. Annual reports about the person's health and well-being and whether there are additional steps that should be taken or whether that can be reduced because the person is able to do more on their own. There are financial reports for inventories. So there may be this relationship. It's like the probate process and similar to civil process, you might begin and end when it's over. But guardianships, conservatorships can last for decades and typically do. So having this place to go to, having these reports to file and a place to ask questions, this formality is very important. Another important aspect is that of this informality. In regard to guardianship and conservatorship, it takes a lot of due process to get a guardianship or conservatorship over a person because you're taking their fundamental rights. But to change a guardian or to terminate a guardianship or a conservatorship, either one, what the law says is that, yes, it can start by a petition. If someone petitions to remove a guardian or to modify or remove their guardianship, they can do that. But the statute also says, and the courts also have to consider if there's a communication. So again, the goal is not put an obstacle in the front of access to justice. So if somebody who's under guardianship, they don't know the formality of what to do, but if they call the court and say, I don't think I need a guardian, or I don't like my guardian, I think they're making bad decisions for me. That communication, verbal communication, puts the onus on the court to look into the situation and see if there's any reasonable belief that a termination or a modification may be appropriate. And if it is, the court has to have a hearing. So that informality, that accessibility is very different than the usual courts where there's a court filing to trigger something. So very, very important, the accessibility and the informality of the probate courts as they exist. The third area of practice that I deal with and that probate courts often deal with are civil matters. They may be interpretation of a trust. It may be modification of a trust. It could be the taxes have changed or change of circumstances. And even in these processes, it's a problem-solving place. It's a place you go and you file your petition. And oftentimes there's agreement by all the parties or the beneficiaries, the interested parties in it. And it's a process that has to happen. And sometimes a court hearing, and sometimes if everyone waives, no court hearing. But the entry is not so significant. And we get a solution to a problem without the more formal court processes that are in existence in other areas of the law. So overall, my 28 years of experience, I'm still kind of young, kind of. Regular hearings throughout the years. Throughout the years, I've had numbers of hearings, but probably about 10 to 20 contests, true disputes where I had to bone up on what is evidence, what's admissible, what's not, all those sort of things. And it's because partly after 28 years experience, a lot of this is because the way the system works. The system invites problem solving rather than that our American belief that the adversarial, the plaintiff and defendant fight for justice. This system in the people's court, the probate courts, is more of a problem solving system, which I think works wonderfully. Probate courts are people courts. They're local. They are form driven for routine matters because we want to make it as simple and as consistent as possible. They're access points to justice in a more informal forum and where ordinary people feel comfortable. And to be honest, ordinary attorneys feel comfortable. If I was many years when I first started was at Superior Court, went to the law court. I wouldn't know what to do in that more formal process where this informal problem solving, yes, we have petitions, yes, we have motions and things, but the access is much easier. So all of us ordinary attorneys that practice in probate court do not practice in Superior Court. And in fact, the litigating attorneys sometimes are a disadvantage in the probate court because that litigation perspective is not as sometimes conducive to a problem-solving perspective. We have fundamental events in people's lives and an informal and a comfortable place to protect lives. And yet the probate courts can gear up to have full litigated proceedings as necessary. So my suggestion, and when I was looking at last night, reading your responsibility, and it said to review and to find and to research to determine a timely, convenient, and meaningful access to justice. Keep the spirit of the probate court because this probate court is timely, convenient, and a meaningful access to justice. There can be improvements. There's 16 county probate courts, 16 counties. I think they're working on this, but more uniformity would be helpful so that when you go to court, it's not, oh, you need this and you need that, and things change and you're not even sure why. So I think the forms can be continued to be worked on, uniformity encouraged. When there are contests, do the probate courts have all the resources they need to develop, to have researched the issues and support for reasoned decisions? I don't think that's the case right now. Should judges be elected or appointed? That's a big question. I do believe that probate courts have excellent judges. I was just with them just last week, talking about guardianship and conservatorships, and most of them had their statutes out, struggling, trying to get uniformity, really working on getting, because what happened is our law changed 2019. We have a brand new guardianship conservatorship, the first one in the country that accepted and adopted this. And so a lot of novel issues, and they're struggling through it and really putting a lot of effort to it, which I was very impressed and inspired. But, in the big scheme, should they be appointed versus elected? That's a good decision. That's a good question. How do you do it if you have it if you don't do every county, because some counties are small, how do you make that access? Do you combine some counties and have a judge that travels? I'm not sure how to address these issues, and that's your guys' job, and I wish you the best. hope that any new plan builds, I don't know why I'm getting choked up, I don't know why. Any new plan that builds on those unique qualities that exist already, because we have a great process. And I'm sitting next to, she's not here with me, but Greta, one of our new attorneys that came from Massachusetts, and they combined their family and their probate courts. And I had asked for input from my fellow colleagues, and she said, it's a mess. It's for probates, it is. And they're often treated secondly because except for guardianships, the emergencies aren't there. So we do have a great system. And yes, we can get better, but I wouldn't just assume that it's better to throw it out. It's just work with it and develop something better. But thank you.
Thank you so much for your comments. I should have left my microphone on so that you had us laughing, and we really appreciate that. Thank you so much. And I think at this point, we'll give Richard Morton a chance to make his comments as well. Go ahead.
Oh, I was going to ask a question. Do you want to hold questions? Do you want to hold questions?
No, go
for-
ahead with your question.
Okay. Ms. Nelson Reed, thank you for coming and sharing your experiences as a practitioner in front of the court. I also have practiced in probate court for a number of years, but my practice has actually been limited to litigation matters. I don't routinely do trust and estate work or estate planning or probate work. I usually only get involved if there's a conflict. So maybe that says something about me. I don't know. But one, I want to say, I want to make clear my experiences in any individual case in probate court have generally been positive. But I have on more than one occasion in more than one probate court run into a problem with a judge in a piece of litigation where if it had been in state court, there would have been some type of oversight of the judicial process. There would have been a chief judge to intervene in case of a decision that had sat for 9 or 10 months without without something coming down, or other issues. In each of these cases where I became involved in a problem, the stone wall that I was running into is we don't have a broad judicial oversight. The state courts were saying that's not our, they're not part of our umbrella. We had 16 silos where unless you can prove that a probate judge is violating one of the canons of judicial ethics, you really don't have any recourse to address the individual problem. And to me, there's a lot of real estate between we've got a problem and we've got a violation. So that has been one of my personal frustrations with the current structure of the probate court. You practice in a very different, generally a different atmosphere that I practice, and definitely a different area of the state. And so I wondered if you could address your experience on any of those issues. Is this just is this just me or a certain area of the state, or is this something that's more widespread?
Good, thank you. They're very good points. I think, well, judicial oversight is a different issue where you can go to someone to get a decision decided earlier and other issues that might appear. That might be something that you work on, working with what we have, but embracing them into a more systemized approach. But I think part of that problem is, especially the time frame, is Right now, the probate court judges generally work part-time. They're asked to do a lot more work, and sometime again with the emergent guardians and conservators in a short period of time, and they don't have the resources. So I have found for the litigation pieces that I've been in, the litigation goes as good as the opposing parties. Like we research, when we litigate something, and we have gone, on issues that we've had to research. They were questions of first impression. That's why we're litigating them. Otherwise, because we're problem solvers, and we try to stay away from litigation only sometimes, but I have been involved. But the reason why we got good results is we researched the heck out of it, and and the other side might have too, but we were both very valid adversaries coming in. But the probate court itself doesn't have the money or the resources or the clerks to go do research motions. And so I do think when I have had cases, they do take a long time to get results. I do think that's how in litigated cases. But my sense it's because they have to find time. And sometimes I understand I remember one situation at least that they were paying their own paralegals to do some research for them because there's no resources to pay. So I think what would be helpful is to know what percent are litigated matters. First of all, I do think it is the minority of percentages, but it might be 80 to 90% non-litigated. They're matters that are problem solving or they're routine, and maybe 10% that's litigated, and maybe that's the lack of resources, number one, but some oversight would be helpful. I think that, again, I don't think it's perfect the way it is right now. We can build on what's there and develop and I don't know where you get money for resources, but I think your point is well taken. It's just how do you resolve that by folding something all in and becoming a sister of a district court or part of it? Or do you keep the uniqueness there and work on that?
Thank you.
Members of the commission, do you have any questions for Patty Nelson-Reed, or should we hear from Richard Morton and then ask questions of both of our panelists? Any specific questions right now? I am not seeing any. So Richard, if you'd like to go ahead. And thank you very much, Patty.
Thank you. And I don't really have much, partly because although I wrote down a considerable number of things, I began listening to you all this morning at 10, and even on the ride down here using the YouTube connection. And you have covered an amazing amount of material in significant depth and perspective. And so it's very impressive, actually, that this early in your meeting process, that you're digging as deeply as you are. So I certainly congratulate you for that. I think one point that I do want to emphasize before I get to what my sort of preferred solution to part of this issue is I do think there's a significant importance to the separate probate docket. Wherever you decide the court should land, I think that the separate probate docket is important. Now, Patty alluded to that a moment ago with regard to her impromptu conversation with the attorney from Massachusetts. There is the potential risk that the emergency and heightened focus on particularly child custody issues will cause traditional probate decedents estates issues to be pushed back with regard to the docket. And that's a significant problem. And probate, from my perspective, is a very specialized area of the law. That is not to say that the current state judiciary isn't wholly capable of being wonderful probate judges to administer this specialized area of the law. That's not the issue. Their ability is not the issue. It's giving them the time and the space and the docket to deal with these issues. We have a specialized probate code, quite complicated and totally redrafted recently in 18C from what was already very complicated when it was originally drafted as 18A. It's a specialized area of the law. It has unique arbitrary deadlines that are peppered throughout this process for claims, for petitions to resolve claims. Newspaper publications are mandatory for a number of steps within the process, which is not part of the current state court system or process at all. Not just notices to find people, which is the standard newspaper notice approval process for civil cases. This is notice to make sure that claimants, make sure that heirs, make sure that anybody interested in the decedent's estate is aware that the estate exists in the first place, because nobody knows who these people are, or oftentimes we only know who some of them are. And it is this notice process which allows us to reach that number of people. There's an entire body of probate rules and procedures, a specialized section separate from the main civil rules and procedures. They do connect with each other, and there are points where the probate rules take us to the civil rules, but nonetheless, they're distinct, separate, and have to be mastered on their own. As was mentioned earlier, there's a large percentage of pro se litigants, oftentimes with very intense disagreements. The judge in a contested probate case can be sitting in a courtroom with 5, 6, 7 unrepresented people and one proposed personal representative who probably doesn't have a lawyer until that person is appointed personal representative, and then they're required to get a lawyer. But up to that point, these folks oftentimes are at cross purposes, not just with the petitioner, but also with each other. And the judge is required to spend the time to work through these issues, oftentimes to have more than one pretrial conference to begin to separate positions out, identify potential issues of litigation. In a sense, I mean, it just is complicated and requires a light touch and the time to deal with these people. The current probate court is flexible, as was noted earlier. It's quite nimble. The probate courts function throughout COVID. They heard cases. They handle a lot of things through Zoom. The registers received filings with almost no interruption whatsoever, except for the limited period of time when people had to drop paper filings off at the front of the courthouse and then have them processed through without being able to come to a window. So there are a lot of aspects to the local processing mechanisms of the probate court system that work really well, and it's a system that has its own definition and its own structure. And in terms of that issue, we have the informal probate process, which we've also talked about a little bit today, and the quasi-judicial nature of the authority of the register, which is working fundamental. It's tremendous in this state. It's amazing how well it works. It's amazing how efficiently the registers process decedents' estates and the appointments of personal representatives in an effective manner, so that, as Attorney Nelson Reed mentioned a moment ago, people come to the court to get their authority. They actually don't get a lot of instruction, which is perhaps a downfall of our current system. Maybe they should get more instruction on how to serve as a personal representative. But nonetheless, they can come in pro se, get appointed, go out, do their business, sell the real estate, deal with the personal property, pay all the bills, distribute the estate assets, and then come back to court and say they're done. And if no one raises their hand to say they haven't done a good job or there's an issue, it's all been done through the registrar's office with the judge never touching it. It would be a shame to disrupt that process. It's local, it's effective, it's efficient. I think it's probably very cost effective for the state. And to the extent that we're going to have appointed state judges who are interacting with county registries, I think that that's a hurdle that's possible to address and to deal with. I can't believe that it is an issue that can't be resolved. And I don't think that the people of Maine, the citizens, would be well served by eliminating those 16 portholes of opportunity to process their legal matters in a local and effective and a friendly manner. So I guess that's really the primary thrust of, after all the things that you said today that I would have mentioned, but I don't need to because you've already really touched on them. I think the most critical part from my perspective is to somehow, if we go to a state, an appointed judicial position and make the judges state employees, is to somehow preserve a probate docket within that. That's why I like the New Hampshire system, having looked at it a little bit, which is as was mentioned earlier, creates a probate division of their circuit court. I suppose it could be a probate division of our district court. We just have to figure out where to put it. And then create as many divisions as you need. If you need a division for York and a division for Cumberland, or maybe York and Oxford, Cumberland, Sagadahoc, and Lincoln, and then other divisions which are broader and cover more counties, but serve the existing county, the existing registries of probate in the various counties. To me, that would serve the people most effectively and accomplish the goal of moving from elected probate judges and elected part-time probate judges to full-time probate judges. We have a separate bankruptcy court that's hitched to the federal court that seems to function. I don't know much about bankruptcy law, I'll admit it, but it's clear that the bankruptcy judges are separate. They function separately. They have a separate docket. They have separate forms. They have a separate process with regard to filing online, and it seems as if it's worked fairly well. In enacting this kind of a new model, as we were talking about most recently this afternoon, it's certainly possible that division could become more than just decedents' estates. It could be a division that it has family law jurisdiction in it as well, as long as it maintains a probate docket, so that decedents' estates get sort of a fair look in this process. That would make sense to me. I have just one other thing I was going to mention. Back when New Hampshire moved from part-time probate judges to their current system, they began to do it quite a while ago, right after we adopted the model probate code. Before that, their probate judges, particularly in the rural counties, were getting paid just by the value of the estates that were coming into their courts. So a large estate, they got paid more; a smaller estate, they got paid less, and they got paid directly from those filing fees. And New Hampshire recognized that wasn't a very appropriate process. One of the things New Hampshire did was to appoint a full-time probate court an administrative judge. And that judge had his own jurisdiction, but he also, as a second responsibility, became the oversight for all of the judges in New Hampshire. And the result of it was that they really stepped their game up in a hurry and pretty effectively in the manner in which they began to develop uniformity. So I certainly can't argue against some form of top-down directed administrative coordination. I think we all would benefit from that. The judges would benefit from it. The people of Maine would benefit from it. So it's certainly a good goal. I guess my only last point is, as you move through this process, I hope that you'll kind of adopt the mantra of do as little harm as possible on your way to your goal. Because there are a lot of good things that are happening now. And some of them will have to go by the wayside. But to eliminate them all, just for the goal of efficiency and eliminating elected probate judges would be a shame. Thank you.
Thank you very much for your remarks. Commission members, does anybody have questions or comments? Go ahead, Representative Cardone.
Just a point of clarification, Judge Morton. You had talked about the top-down supervision. Were you talking about that in conjunction with going to full-time state-appointed judges? Or were you talking about that as an alternative to going to full-time state-appointed judges? I wasn't sure how that fit into the other things that you were suggesting.
The former. I was envisioning a probate and family law division of the district court where the senior judicial officials were providing supervision, direction, assignments if necessary. Frankly, just to answer your question a little more broadly, I understand the judicial selection process and the idea of recruiting judges who have an interest in probate, an interest in business law, trying to expand the pool from just former prosecutors and assistant attorney generals and people who are kind of more well-known, I guess, within that sphere. And I understand that, but I actually have a lot of faith in the judicial system, in the Chief Justice or someone designated by the Chief Justice as the chief family law and probate division judge, to assign people within that structure who would do the best job and are most interested, and maybe rotate them through so that more people become well-educated and more able to perform judicial duties in that area. So that's what I was referring to.
Thank you.
Other questions and comments from members of the commission? Go ahead, Judge Carr.
Thank you for coming, Judge Morton, and I'll probably always call you that because you helped me out when I first got started. So in New Hampshire, all the registers and the clerks are paid for by the state. And so that's always been an issue, that we've run into here, is that if we do an appointed judge and you have county employees and elected officials, there's going to be a problem. Is it possible? I know the Futures Commission mentioned something about elected probate judges for districts to make them full-time, and you were part of that process. Would it be possible if they were elected that the chief judge or the chief justice would be able to add an additional duty to one of them as the overseer of the sort of a intermediate portion? Because the problem we're running into is money. If we try to convert all the registries, I'm calling a spade here in this situation. We're not going to have the money to do that. I don't think that's realistic, but we need to find a way to get to full-time judges, I think, is what the goal is. But is it possible, or what are the downsides you saw as far as the Futures Commission or Futures Committee? We were trying to search for the answer. I'm hoping you can help us here. knowing the fiscal restraints.
Well, my memory of the Futures Commission's decision is slightly different than yours. I don't ever remember signing on to a vote for elected probate judges in districts. The position that I finally took after a fair amount of consideration was full-time state probate judges in districts. And as I just alluded to a moment ago, I'm sort of rethinking that because I really like the concept of divisions of the district court. And I also think that's more palatable to the state judiciary as well. I'll be honest with you. I have heard your concern with regard to the interface between the state judge and the county register, elected register, for a long time. I think you just have to solve it. I think you have to step up to it and decide this is the way it's going to be, and then work out whatever the issue is that comes up after that. If it can't be resolved, so it means that county registers need to be appointed rather than be elected. I suppose down the road, that's one of the solutions. As I recall, the Court Futures Commission kind of dropped the issue the same way. We said, let's elect the judges first, let's create the jurisdiction for them, and we'll worry about the registers later. Leave them where they are for the moment. Maybe, I just can't believe it's insurmountable. I can't believe it. I mean, and well, let me say one other thing. I understand, having watched and been in the middle of the jail controversy for years now, that the state county head knocking over jail funding has shown us that these are significant issues. I understand it, but I just think it has to be faced, and you can't let this process stop because you can't figure out how to deal with elected registers of probate. It just doesn't make sense.
In a moment, but I just wanted to ask our other panelist, Patty Nelson-Reed, if she wanted to comment on any of the discussion to date.
The only thing I thought might be helpful to mention, when I was speaking with Greta Atkinson from Massachusetts, who just joined us in June, she said for the first 7 months of COVID, the joined family probate court did not process any probate estates. They just said they had to focus all their time on the emergency family matters, children's rights, things like that. So it came to a complete stop. And she said, typically, even though the courts are committed, the probate matters come second all the time, and they just take forever because they're just not at primary. And so she had found that combination of the two without having, I like the bankruptcy concept because the bankruptcy has their specialty and that they're an adjunct to the federal system, but the true combination of asking judges to do both areas, it just may be too much, and you just may not be able to address the justice issues from the more urgent issues. And I think what the response she got always from decedents estates was that there's no rush for a dead person. They don't need to be protected anymore. Yes, their estate needs to be managed, but we only have so much we can do here. So I would just be concerned about getting lost. As well as Dick mentioned, the specialties of, it's hard to know everything. That's why attorneys specialize, because it's hard to know it all. And asking the judges to know it all, unless you have a separate division and they're separately responsible. Other than that, I agree with Dick that one thing, this has been visited over and over again, and the issue of how to coordinate some elected officials and appointed others, it should not be insurmountable. There are solutions here, and people have to give a little bit.
Do you think a separate division is a workable solution as a practitioner?
Possibly, if that's the way to go. I do think Barbara brings up a good point about having some oversight. You have to be able to go somewhere if you're having a problem, so whether it's an oversight person in the current system or a division of the district court. But I do think, as Dick brings up, that accessibility to 16 places, the people's court is important. If you say, oh, well, we're going to have it just here or there, you're decreasing people's access to people problems in people's court.
Thank you for those observations. Justice Gorman?
So I guess I have a question. I'm going to demonstrate my ignorance. My understanding is that the resolves in 1967 that repealed Article 6, Section 6, also repealed the obligation that the registers be elected. And Judge Crockett keeps talking about that as though they must be elected. I can understand from a funding purpose why, if you continue with the county funding, the county might want to have them elected, but there's no longer a constitutional requirement that they be elected, is there?
Go ahead.
I completely agree with Justice Gorman's interpretation. I don't think they have to be. I think the whole idea is the whole system could be rolled in. And that's the Cadillac version of the plan. But the political realities that we've all experienced and why we're still here 50 years later is that will never, unless someone has a large infusion of money that wants to convert all the clerks over. I think the Superior Court did it in the late 70s. The county employees of the Superior Court became state employees. I think that unless if that infusion of money is available, we think that's a viable option, then I'm on board. But I'm trying to find a workable solution that is a little less costly.
But they don't. But even if they're still funded by the county, there's no requirement that they be elected.
I don't think there is, but I'm pretty confident the counties are going to have some. Well, I know at least 2 counties are going to have severe pushback if that's the direction the state wants to go. So.
Okay, thank you.
I do believe there's a timing issue too, because you cannot just get rid of elected officials and the Constitution, so you're going to have a timing issue if you want them to be state employees.
No, I understand that.
Yeah.
To the extent that there are currently any who are serving in office, and there's a proposal from the legislature that they no longer be elected officials. Obviously, those who have already been elected would have to be allowed to serve out their terms.
Right, and that could be with another election coming up a while.
How long are the terms currently?
4 years.
Are you finished with your comments? Oh, okay, go ahead, Judge Mitchell.
This is a question to Justice Gorman, if I may. I've listened to the presentation here, and also I always want to call you your entire name, Patty. I may call you Patty, of preserving. And we've been talking all day about preserving the best parts of the people's access and the local access. Could you envision a system of probate where there was a local office of registers who perform the day-to-day wills and estates and helping people through the form-driven process that we have, and a division within the state court with state-appointed judges? Can you see how that would work together?
I do. But again, I've never been a probate judge or a register. And one of the first things that you talked about was how closely you and Ms. Ayers work together. And to continue my use of real estate, there's not a lot of real estate between what you do and what she does in terms of collaborating and figuring out which ones can stay in the informal process and which ones can go to the formal process. And I think that's where Judge Crocker was talking about. There might be from time to time tension in terms of who actually has the final say. if you've got an elected official or you have an official who answers to county commissioners by way of an employment contract versus a judge. Not that I think Representative Cardone will agree with me on this, not that the clerks always do what we tell them to do, but we like to think that they do. And so there's just, I think it's complicated, but I can't say that I would disagree that there's no way to have a hybrid system. I think given what I've heard today about all the good things about the probate system and all the things that we should seek to preserve, we should think carefully about coming up with a hybrid system that would allow us to, as Judge Morton says, keep what's good. I think there do need to be some fixes. I agree with Professor Smith in terms of the problems with ongoing part-time judges. But there's so much good in the system, and to the extent that we can keep it, we should do so.
It's almost if you would divide the areas, it would be the litigation that would be divided, like the routine administration and even the big, I don't know if this is practical, even the problem-solving part where someone may think they have differences, but they agree literally after the meeting because they understand more. But it's the true litigation that gets boggled down, that maybe we don't have the best decisions because there's no resources underneath it and the uniformity. I don't know if there's a way to trigger litigated matters up there. And if you did, when it's litigating guardianship and conservatorship, that's so specialized, someone really, and they understand that, I guess, I don't know. If I was to pick what I would keep in the probate system, probate's local access, and what I would give a different level, I don't know if it's a higher level, it would be the true litigation piece. That there's no time and the resources, at least on that level, to similar to this true litigation in other areas of the law, other courts.
Well, and the question is really to Judge Morton, because I was going to ask this before I responded to Justice Gorman's question.
He may want to comment on what Patty Nelson Reed's
Do
just
you want
said.
to
So
proceed? And I can just ask.
let him comment and then you can have your question.
I was going to go back to something that Justice Gorman was discussing. And earlier in the conversation as well, there was this issue about how do we decide what the register does and what the judge does, and is it possible that their roles would change? And I really can't quite put my head around that at all, because their functions are entirely and completely different. I was married to the Register of Probate in Franklin County for most of my 36 years of service. And she did not ask me whether she should informally probate an estate, nor did she let me tell her that she should or shouldn't, because her quasi-judicial role and my judicial role were different. And there was a very large line between the two. She didn't come to me to get advice on which way to go. In fact, I always said to her that it would be improper for her to do so, because otherwise she wouldn't be a quasi-judicial official. She would merely be a clerk, a processor of information. She had to make her own decision. And then I had to deal with whatever decision she made. Or if it didn't come to me, the public had to deal with the decision that she made. And of course, the public always had the right to take the case away from her and petition for me to deal with it formally if they didn't like what she had done. So I don't think that's an issue. I don't think, frankly, aside from supervising issues like docket timing, court scheduling, hearing processing, and how you manage the number of people who have come through the door in anticipation of judicial time, I don't think that relationship between a state-appointed judge and an elected register of probate is a real issue. The only issue is money. Now, most of the time, the only issue is money. I mean, we've had problems between registers and probate judges in some counties when they were both elected and they didn't get along and neither could get the other to do what they were supposed to do. So I don't think that's unique to the idea of appointed judges and elected registers. The real issue is money. The real issue is who pays for appointed counsel, who pays for appointed guardianships, who pays for the courtroom. That's, to me, those are the issues that have to be worked out. The professional relationship between the register and the judges, I don't think is going to be an issue.
Thank you very much. Go ahead.
I would concede if we had an infinite pot of money, you would be correct. But I've seen two instances in the last 10 years where a judge has had to go before county commissioners and reallocate the register's money per the statute. And I cannot imagine that a state appointed judge is going to appear before 3 county commissioners and ask for the reallocation. I'm not sure how that would go. And if they didn't get what they wanted, how would that work? So I agree with Judge Morton's, the professional distinction between the two jobs, that's easy. That's not an issue. The issue is, how do you do that? How do you, if the state wants to fund the registers like they do in New Hampshire, where they elect the register and it's funded by the state, and you have appointed judges that are voted by the executive council, I think that's an excellent answer. I think we go that direction. But what I'm trying to bring the group back to is that you have at least 2 sets of county commissioners that are probably not going to support a state appointed judge reallocating and overseeing an elected register. So I think we need to take the fiscal constraints and kind of observe them. If we're doing the Cadillac program, then by all means, I will go along because I think it is the right answer. I would love to see it. I think it should be done. I just would like to actually see this commission have forward progress other than, Futures Commission was 28 years ago, the various reports that have taken place. I want to see us make one step forward, even if it's a moderate step. And I know that's an evil word in today's world, but I'd like to see some step. So I just throw that out for food for thought.
Thank you. Yeah, and that duly noted. And let's see if we're just about at the end of our practitioner panel. And I want to see if there are any other information, ideas, suggestions to get on the table before we finish up. And I see, go ahead. No, you can go ahead.
I'm going back to Justice Gorman again, because I honestly see this as a true marriage of 2 systems. We keep talking about the Cadillac model. I don't even know how much a Kia cost in this thing. So if we took, please don't shoot me, Kathy. If we took this court system, which is now funded by the county, left it local and left it under its own set of statutes so that people can go in and do the informals and all of that other stuff, and you had to pay for them, what information do we need? How do we know how much this cost? How do we cost that out?
Well, that's what we've been talking about, or Jared and I were talking about earlier today. For the Home Court Act, Ms. Ayers and her compatriots gave us all of the information that we needed so we could figure out essentially, well, I would say, Kathy, you can disagree with me, but I think we heard from 13 counties, not all 16, but I think we heard from 13 counties. And we then were able to make an educated guess about how many cases would end up in the state system. In order to make another educated guess about how much it will cost, we need to have numbers. We need to know filings, and we need to know case times, and we need to know another number of employees, because if we're going with the Cadillac version, then probably everyone in the office would be coming stateside. If we're going with the Kia version and everyone is staying county side, there are still judicial salaries that would have to be transferred over. And there would also be a need for additional clerks within the state system to absorb the work of the newly created probate and family division, or whatever we call it. And I love Dick Morton's allusion to the bankruptcy within the federal system. I think that might make sense. But again, all of this, we can't even make an educated guess without knowing the numbers.
Thank you. That was a great question and a great answer to bring us to our final topic tonight or this afternoon, which is discussion of next steps. And before we get to that, thank you so much, Dick and Patty, for your contributions and for serving on our practitioner panel. We really appreciate everything you've shared with us today. Yes, please do.
You ask about how probate judges got educated. I'd like to point you to the man that's on speed dial for all of us. He took us all under his wings and he can tell you anything that was ever presented, but he was very, very helpful. So that's the way we get educated. And there he goes. Thank you, Judge Morton.
Thank you. Yeah.
you.
So at this point, what I'd like us to do is to have a kind of robust, if short, conversation about the information we feel that we need in order to make a really informed decision about the Cadillac versus Kia or anything that might lie in between those two extremes. And we've had some great suggestions from Justice Gorman. And Kathy, can I just ask you, do you need more detail on those categories? Like how
Well-
definitive do we need to be when we're describing our information needs?
Well, you're talking basically all the proceedings, all the same spreadsheet that I gave you last time with all the names of the petitions and how many we had. I'm not sure how I'm going to do court time or give a formula to them to give me back a court time. And whatever else you need. I mean, we're talking all salaries. That may be something that we have to talk to county administrators about because we have no breakdown in the public documents or the budgets, you know, if each office is a lumped clerks. So that may be something we need from the McCam, the Association of County Administrators.
Okay.
Is there anything else though that would be helpful?
Let's just, all of us who are part of the commission should be chiming in here. And so if you please raise your hand and if you have additional requests, and I know that you had your hand raised first, but we haven't heard from Leo yet. So Leo, go ahead with your request and then we'll go to Barbara.
I'm wondering if it would be useful to have a breakdown of the case numbers in terms of formal and informal. Just to try to get an idea of how many matters are handled by the registrar's office and how many actually need a judge's touch. And then I don't know whether the statistics exist, but the number of contested cases that actually need a hearing or contested motions that need a hearing.
That might be a little more difficult one, only because all formal, but you heard, not all formals are contested. So it's going to be a matter of most likely looking at the calendars and seeing the time. And even for me to break that down, that's going to be labor intensive. So I doubt I'll get an answer from all 16 counties, but I can do some kind of rough estimate. You know, how many days they're in the office and doing court, because they don't usually, a lot of them don't do their research in court and in the office. They do it at home in their private offices. And so, yeah, that's going to be a little bit tough one, but I'll try.
I'm wondering whether you gave me an idea about the appointment calendar. I'm wondering whether Incon, is it Incon? Icon. Could mine the database and just look at dates and names of cases. So if you see 10 particular case events for that particular case, it might be a contested case.
The other thing is attorney appointments. it would be a good, that's, the way you suggested is probably not, I mean, hearing held, we should be able to, I'll get you all the hearing information we can. Hopefully it'd be more.
Thank you. And then we're going to go to Representative Cardone and then Tudor Goldsmith and then Julie Howard.
I think these have been covered. The most important thing for me is judge hours. And if we can't get judge hours, backing into it by trying to get contested cases and how much extra time do you put into your writing or whatever, because I don't know if judge hours is logged in any particular way. The second thing that I would like, if we're going to deal with the court-appointed counsel piece, if the state's going to pick that up in some way, shape, or form, I'd like it as attorney hours as opposed to total amount of money paid to attorneys if we can, just because if the state does it, it's all got to be uniform and it's all got to be at $80 an hour. You don't use guardians ad litem that much, do you, in probate court?
We do use guardian ad
Okay,
litem.
then guardian, hours for guardians ad litem as well, if the state is going to be picking that cost up. Pardon? Yeah, and the state doesn't use visitors per se, but so maybe we should still get them as in case we have to pay for them. We should get the hours for visitors also.
Depending on a county, how big a county is, that's going to be the hardest get, I think.
Okay.
It will be.
All
It
right,
will be
well-
because it's done and you would have to go back and pull the bill and look at it.
Okay, all right, let's do what we can.
Okay.
And finally, this is an ask for Judge Crockett, because I heard you 4 years ago talk about what we've been talking about, this county-state interface. And I tend to believe, I tend to be siding with Judge Morton and Justice Gorman on this, that this is solvable. But I was much more focused on what Judge Morton was talking about, the professional relationship. And until you brought up that point about, I've seen 2 judges have to go advocate in front of county commissioners. And it's okay. And as soon as you said that, I thought, oh yeah, that's a problem. What can you articulate or point me to the statute or something? I would try to get a list of things that probate judges currently have to do that they might not be able to do if they were state employees. That's where would we have to tinker with this? Sure.
So the issue, and Professor Smith alluded to it earlier, is that each judge, and this is a problem that why we'd like to get some of this fixed, or at least get it more uniform, is that each judge is its own chief justice. You technically, you have oversight of the register. If the budget is off, then you're really supposed to, most counties, the register pretty much does everything with the commissioners, but there are provisions under the statute where pay, and I think it's happened, I know it's happened in my county before, an attorney became the register and thought he could just do it part-time, and we had to reallocate money, and it wasn't me who had to do it, predecessor, but there is a part in the statute where we have to go to the county commissioners. And you are your own chief judge. That's one of the problems. In the DA scenario, this is why I keep preaching this district piece, is the district attorney does that with each of the 3 counties. Like in Penobscot, you have Penobscot and Somerset together, or Penobscot and Piscataquis. So the DA goes to both of those counties and coordinates for office space and employees and so forth.
Okay.
That's why I was pushing that model, because I've seen the information you're looking at, like the judges' hours, that is the better piece of information. And we'll try to get it directly from the judges that represent the assembly. We'll get that, because the problem with the informal cases and trying to break it out like that, it's not possible, because an informal case can become a formal case with one complaint. And I just opened one up after 6 years of being informal. Now it's In the open docket count, we have estates that go back forever.
Going back to the DA model,
Yeah.
the DAs are paid by the state.
Yes,
I know you said, but the difference is they're elected. And I'm
Yes.
not sure that is a difference. How does that make a difference with the county commissioners?
because
I'm going to call a timeout here
Okay.
for
No, she's
one
gonna go
moment. And that is because we've got 15 minutes left and we're trying to generate a list. And this seems like an ideal subject matter to which we can allot an hour at our next meeting. But I think
I am
if we
trying,
can focus on like what the information is,
Yeah.
and then we'll deploy that in a presentation next time.
and that is what I'm trying to get to.
Okay.
What is, where's the rub here? Okay. All right.
Yeah, that would be extraordinarily helpful. And thank you for talking offline about the other matter and bringing it back to us. Okay, so Tutor Goldsmith, go ahead.
Hi, so one thing that would be an interesting maybe piece of data to mine from ICON would be the lag time on dispositive motions and contested matters, particularly like civil matters particularly. I share Representative Cardone's concerns about that sometimes, and not always, but sometimes the way probate litigation, the course of the litigation and sometimes cases not being decided. And, you know, Patty Nelson Reed's point about, oh, there are people who come into probate court and, you know, they're at a disadvantage. She viewed that as a positive. I view that as a negative. I don't think that anybody should go into a court feeling like, oh, because I don't practice in this court, I don't know what's going on. So that level of uniformity, I think, is really important as a matter of justice and equal justice. And again, I don't know whether the ICON software, excuse me, sorry, whether the ICON software is capable of getting that information in any kind of simple way. Certainly asking the registers or the staff of the probate courts to come up with that would be really an intensive ask. So I wouldn't necessarily suggest that.
Thank you. And Julie Howard, go ahead.
Thank you. I can defer to Justice Gorman. If she wants to go first.
Okay, go ahead, Justice Gorman.
So one of the things that we talked about was the possibility of, and I can't remember who said this, that the family type cases go to the district court and the estate type cases and maybe the registrar's office go to what we think of in the state court system as the county courts, which are the superior courts, because they are housed in the building where the probate courts exist. They are a county by county, whereas in the district courts, there can be, in your county, for example, 3 different district courts in the county. Although, as God is my witness, that will change at some point in the next decade. But anyway, and for that reason, it would be very helpful. And Ms. Ayers is going to have to tell us when she really can't get this information. If we knew what the breakdown was in terms of case types. So the trusts and estates, the wills, the actual, what I think of as pure probate, how much of that comprises the docket in any given county, and the family probate cases, how much of that comprises the docket? Because that would be another useful piece of information in terms of judge time.
That's pretty, if I get all the cases, then you will see.
Okay, great.
You will see the breakdown, yeah.
Great.
Now I can take my turn.
Go ahead.
I think there are a number of things that we need, because otherwise I think we're shooting at a ghost here. I think we need what each county's probate budget, I just wrote this down, which is why I'm looking this way. Each county's probate budget with all the line items for all the expenses for the probate courts, case numbers, judge time, bench and writing and research time. You know, how does that break down? I think we need numbers of staff, what the positions are, what the responsibilities are. I think we need, as somebody mentioned, attorney appointments, we need guardians ad litem information. We need intangible, somehow we have to quantify the intangibles like space, equipment, administrators, if we're going to appoint any administrators other than the Chief Justice. And I think we have to look at what would be saved by having a centralized HR, payroll, all of those sort of things that are, economies of scale, if you will. So, and the other thing is the space issues. I mean, I think we have to look at that because I know that in York County, for example, there aren't any courtrooms available. We'd have to use the probate court still because there's no room in the new building either for probate. So that's just one county. So, yeah.
I'm sorry to interrupt you, Representative Cardone, but I just wanted to mention, it sounded like you might be reading from a list that you jotted down. Could you please send that to Janet and Sam and everybody else who has made a little list as we've been talking? If you could email it to Janet and Sam, because they're working furiously to record great notes, but that would be very helpful to them.
I was speaking really fast. I'm sorry.
No, it's very, very helpful information. Go ahead, Representative.
Julie, I was just going to say, I think that a lot of what you're asking for there is actually state information, and that's why I made sure that somebody from the AOC was on this panel. Catherine, is that information that you can get for us?
Not for the probate courts. We don't have that information.
Well, you would have it if it was transferred to state court, correct? Judges' salaries and on space costs.
You're talking about the salaries for judges in the district court and superior court for cases that are.
I think that's what some of what Julie was asking about, correct?
No, I think she was saying we need the probate judges' salaries. We know it's public information what the state judges' salaries are.
Yeah, but what we really need is to price out how much it costs for a judge.
Oh, we know that.
And I know Ted Glessner has that. So I think to go along, it's the probate judges' salaries are not all that important because they're going to vary from county to county. And no, they're going to vary from county to county, and they're all part-time. What we really need to know is the cost. How many judges are we going to put in? And we need to know the cost of the full-time judges. In terms of renting courtroom space, is that a standard price throughout the state, or is that going to vary from county to county or building to building?
Ideally, we would continue to use the existing probate court space because there's no reason not to.
Right,
Yeah.
but in some cases, for instance, in Bangor, all of the courts except the probate court are in the new Judicial Center, and I don't think that the state is paying rent in 97 Hammond Street anymore, the old Penobscot County Courthouse. So if you were going to continue to use the probate courtroom in Bangor, you need to, I think the state would be on the hook for rent for it. I'm not sure how true that is in every other county, maybe not, but I'm not sure what they're paying rent for and what they're not paying rent for now.
No, I agree. I think we're talking at cross purposes here because it would be great if we knew what the probate judge salaries were so that when we came to dickering with the county commissioners over probate court space, we would be able to show them how much they're saving by no longer paying the probate judge salary, and therefore they should cut us some slack on renting space in the building.
I was thinking in terms of arguing to the legislature what the fiscal note on the bill is. So
we're going to have to do all of that.
Yeah.
Yes, go ahead.
One is I'd like to know the percentage of records that have already been scanned and the percentages by county that haven't been, because we have, if we're going to turn it over to the state at all, if that's one of the Cadillac options, we need to know what that cost is going to be to, because I'm sure the state's going to have to take possession of some of these things. And then the other piece would be in the 70s, and Justice Gorman could probably correct me if I'm wrong, although I know she's much younger than that. There's the Superior Court clerks, as I seem to remember a story that they were county employees and then they were converted to state employees. And I can't remember how that took place. And I was hoping someone with some institutional knowledge, because that would also factor in terms of the registers if they converted to state employees.
Jared, I was in college in the 70s.
I was born then, so. Yeah, so, but there's got to be someone with the judicial branch. I remember Donna Howe used to have this sort of information. I don't know if Professor Smith had it or one of you, but it is relevant because they had to do a conversion of the expense of the pay. And when the conversion took place, I think the registers or the clerks are very happy not to be county employees anymore. So.
Yeah. And there may be more recent information or more recent situation that would provide us, with that information as well. If we can't go back to the 70s.
That's true.
Yeah. Okay. Got it. Understood. Okay. Other pieces of information that we feel we need? Go ahead, Judge.
Very briefly, don't throw anything at me because it's 5 o'clock.
We got 3 minutes.
The elephant in the room is technology.
Mhm.
Our systems don't talk to each other.
Mhm.
And I don't know what I want you to find out, nothing, because nobody knows anything at this point. But it's an issue that must be dealt with at some point.
And it
Yeah,
is an
that's
issue.
great.
No matter what.
I've talked to Ted Glessner about it in general, but I don't know if we have any. He was going to at some point look at specific costs for conversion of everything. In the interim, I think I talked with Chief Justice Softly, who said something about an agreement with the counties to allow the state to use their system. I can't remember what she called it. But there was some sort of affirmation or something about being able to use the current system for the judges, the state employees being able to use the current county system or something like that. I talked to her a couple of years ago about this when we were looking at this in the 129th legislature.
There are licensing issues and also you might be referring to a memorandum of understanding, maybe?
That's what, yeah.
Judge Mitchell is right. One of the first things we do, and one of the things we will have to tackle is allowing the systems to talk to each other, and that will be a difficult transition.
Okay. That's a somber note to end on, but it is actually, we're 1 minute from 5 o'clock. Thank you, everyone, for all of your excellent contributions today. Where we go from here is that I think that the analysts and Representative Cardona and I are going to meet and do a debrief. We had kind of roughed out an agenda for all 4 of our meetings to make sure that we used our time really effectively. We're going to adjust that because today certain things have come to light, like even this last topic that we talked about that we hadn't incorporated into our agenda. So stay posted. I think we are meeting 2 weeks from yesterday. Is that right, Sam and Janet? Okay, so 2 weeks from yesterday, we will meet again, and we will meet here and also have the remote option available. If you have thoughts as you're heading home tonight or washing your dishes after dinner, please feel free to email them to Representative Cardona and myself and Janet and Sam, and that way we can take them into account in formulating our agendas for the remainder of our meetings. And Barbara, I turn it over to you for the last word.
Thank you.
Thank you so much.